Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Thank you. Welcome this morning. We have 6 oral arguments scheduled. We'll take a break at some point, probably after the third, maybe after the fourth case. Anyone wants it earlier, just raise your hand. The first case we have is 24-1418, United States versus Munoz. Mr. Jackson, you may proceed.
Good morning, Your Honors. May it please the court, Robert Jackson on behalf of defendant appellant Miguel Munoz. Mr. Munoz and his wife were traveling by car from Colorado to the wife's aunt's funeral in Kansas City. Highway Patrol troopers Ruiz and Ranieri conducted a traffic stop on eastbound I-70 in Kansas. Contraband was found in Mr. Munoz's vehicle. The evidence flowing from the stop must be suppressed for 2 independent reasons. First, Mr. Munoz did not violate any traffic laws, such that the stop was justified from inception. And second, the officers unreasonably extended the stop. The trooper's vehicle had a dashboard camera which recorded the stop in a few minutes beforehand, and that was Exhibit 2 to the suppression hearing, and that's in the record here. However, no violation is depicted in that video recording. Next, the troopers unreasonably extended the traffic stop. Mr. Munoz was issued a warning, but he was not informed that he was free to leave. Eventually, Mr. Munoz consented to the search of his whole car. A pistol and suspected fentanyl pills were found. The extension of the traffic stop was neither consensual, nor was it supported by a reasonable suspicion of criminal activity. Next, following his arrest, Mr. Munoz was interviewed at the station. He consented to having his cell phone searched. It was likely a more invasive search than Munoz anticipated.
Before we get there, it looks like the license tag violation was pretty cut and dried. Am I missing something on that?
You know, I think so, Your Honor. I don't think that it was cut and dry. If we talk about that first alleged violation, the tag violation, the law is clear in Kansas. The Kansas Supreme Court and this court have had lots of opportunities to construe the statute 8-133. And the law is that the tag has to be visible from a safe following distance. And that's the critical question, if the tag's visible from a safe following distance. So we got to think about Trooper Rule and Trooper Ranieri's testimony at the suppression hearing. Rule testified that as he pulled into the highway median, heading westbound, he observed Mr. Munoz's vehicle at a perpendicular angle, headed eastbound, and the paper tag was sticking straight out and flapping. And then Trooper Ranieri, I don't think so, Your Honor, because we're not at
State versus Jurgen Charles from the Kansas Supreme Court. It said there's 4 things that the statute requires, and failure to comply with any one of them is a violation. And the first is that it's securely fastened to the vehicle. And so if it's flapping in the wind, it seems to me it's not securely fastened. And that would be enough under the Kansas Supreme Court's interpretation of this very statute.
Your Honor, I respectfully submit that the tag was fastened securely enough here to comply with the statute. And the reason I state that
do you disagree that it was flapping?
I disagree. It's not depicted in the Highway Patrol troopers' dashboard video camera.
That's not what the district court found, though. I mean, are you saying it's clearly erroneous that what the district court concluded?
I believe it is, and I think we have to look at this court's rulings. I think we look at the cases of Edgerton and McSwain, and in those cases, there were some temporary tags that were taped in the rear windows of cars. And this court held that once those traffic stops were initiated and then those officers confirmed that those temporary tags were properly displayed, the stop should have ended there. Right then and there, those officers should not have even asked for ID.
Are you suggesting that even if it was flapping, there was a point in time when the officers could see it because it had quit flapping? Is that enough in your view?
Well, when the officers get out of the median and they give pursuit and they find themselves at a safe following distance, there was no flapping. They never observed any flapping once they were behind Mr. Munoz's vehicle, and they agreed on that at the suppression hearing. And then we have many minutes of footage from this dashboard camera along the shoulder of the highway there in Kansas, and the wind's blowing. You can hear it through the microphones. You can see the vegetation on the side of the road blowing, and this tag stays right where it's supposed to be.
So
right
if
on
it's
back
moving
of the
down the
lift gate of this.
highway, so if you're driving down the highway at 60 miles an hour and it's flapping, so no one can tell what your license number is, that's not a violation, because once you're pulled over for something, it's no longer flapping and you can see it?
Your Honor, the tag also wasn't flapping during the pursuit at highway speeds, and the troopers agreed.
That's not what
to
the
that.
district court found. I mean, the district court found it was, and that's what the officers said.
And the officers observed it flapping at either a perpendicular vantage point or traveling in opposite directions, both at highway speeds. And that's not a safe following distance, I'd respectfully submit.
Well, it's not an issue of whether it's flapping. I mean, it's an issue, according to the Kansas Supreme Court, of whether it's securely fastened. And, you know, they saw it wasn't. And you can see on the video, he takes Mr. Munoz to the back of the car and he shows him that the tag is not secure, right?
That's officer rule, and he physically lifts the tag.
Mm-hmm.
That
Well, if
doesn't
it were
mean
secure, it wasn't taped down, so he could lift it.
it was fastened at the top, and I don't know how, and he could lift it, but the video recording shows it staying in place. I do need to make an argument about this element of whether the tag's securely fastened versus whether it's visible. In the district court, at the time of the suppression hearing and in the briefing in the district court, the government made the argument that the tag was not clearly visible due to its flapping, and it only became visible once the vehicle came to a stop. This alternative argument of secure fastening, that's being raised for the first time here on appeal. And so with that being raised for the first time on appeal, I would suggest that the court should not consider such an argument. Second, the recording of the trooper's vehicle in pursuit of Mr. Munoz after he was stopped, again, it shows the tag to be visible and legible, which confirms that it's secured good enough for statutory purposes. If we want to talk about secure fastening, I would suggest we look at the Lopez Estrada case that's cited by the government in its briefs. That case is very helpful. This court included a photograph of the tag in that case that was dangling by a wire from the frame of a pickup truck. And that gave a reasonable suspicion that that tag wasn't securely fastened. We're a world apart from Lopez Estrada and the dangling tag in that case. Here we have a tag that's covered in cellophane and it's affixed by its top to the liftgate of the Jeep where the manufacturer intended it to be mounted. I'd like to move on to the second alleged violation with respect to the fog line violation.
Sure.
First, Mr. Munoz denies traveling outside of his lane. And even if the court finds that he did, this touch of the fog line was the sort of minimal and lane breach that would not violate this law. Again, we have to look at the dashboard camera recording, and that recording doesn't appear to show Mr. Munoz ever driving atop or crossing over the highway's fog line. Trooper Rule testified that he couldn't even see in the recording where Mr. Munoz traveled on or across the fog line, but he testified he recalled the crossing. He was very clear, and this is helpful to Mr. Munoz, that the Jeep never drifted all the way over the fog line. And this court's found the drifting over all the way over the fog line critical, like in that Angeles case. Trooper Ranieri, he testified somewhat the opposite of Trooper Rule. He could not recall the Jeep ever crossing over the fog line, but he asserted that he could see the violation in the video recording. He said that occurred at 1 minute 31 seconds into the recording. I'd respectfully request that the panel review that recording. It sounds like you all already have. And even the government takes the position that it can't be seen one way or the other on the video of Mr. Munoz cross the fog line.
Let's move to whether they unreasonably extended the traffic stop.
Okay. When we have a traffic stop, it only can be extended on two bases after that stop is concluded. One, if Mr. Munoz consented, or two, if the troopers developed a reasonable suspicion criminal activity was afoot. As argued in the opening brief, the extension of the traffic stop, it wasn't consensual. It involved this very controversial Kansas two-step procedure, making it appear that Mr. Munoz consented to further a question when in fact he didn't. In that case, that Shaw versus Jones case is currently up on appeal in the court. That was a 1983 case. Anyway, the government doesn't defend the extension of the stop as being consensual. It's not defended in its brief. Instead, the government argues that the troopers had developed a reasonable suspicion of criminal activity by the time they issued the warning citation. And I'd submit that assertion's undercut by the fact that the troopers engaged in this two-step charade to give the interaction the appearance of consent. That was completely unnecessary if the troopers believed they had developed a reasonable suspicion at that time.
Well, their subjective thinking is irrelevant, is it not? We don't
Their
care what
subjective thinking's irrelevant.
Of the officers. Yeah, that's irrelevant. Even if they thought that the consent was not valid, that's irrelevant. The question is whether it was valid. It's just similarly, the question is whether there was reasonable suspicion, not whether the officers didn't think there was reasonable suspicion. And I question whether we should say if the law enforcement uses belt and suspenders, which is not unusual to think where they think they have reasonable suspicion, but just to be safe, they'll ask for consent. That should not undermine the claim of reasonable suspicion, should it?
I think the officers' actions and this history of this two-step in Kansas, I think it does somewhat undermine the reasonable suspicion analysis. Let's get to the reasonable suspicion analysis. Let's talk about the totality of the circumstances here. These officers run record checks on Mr. Munoz. They find out he has no prior drug history, and his criminal history consists of 2 prior misdemeanor arrests. And then the officers fault Mr. Munoz for being physically nervous. His hands were shaking, and he had a nervous voice. But this isn't the extreme nervousness that this court's relied on before. Also, they chalk up to nervousness this unfounded statement that Mr. Munoz makes about traveling to the wife's aunt's funeral in Kansas City.
Well, he just kind of blurted. I mean, he immediately blurts it out.
He does. And
in response for, I think, give me can I see your license? He sort of blurts it out.
He blurts it out, but anyone who's been stopped by a law enforcement officer fully would expect to be asked, well, your plans or where are you headed? He'd be the officer to ask him the question. The district court and the officers faulted Mr. Munoz for giving unspecified travel plans and that they weren't tied up or he didn't know where exactly in Kansas City he'd be arriving. But this is somewhat inconsequential as his travel to Kansas, it may have been unusual that he didn't know what address he was going to, but it wasn't implausible. It was his wife's family member who had passed, and they were on their way to Kansas City. These weren't implausible plans like in other cases where a vehicle stopped 200 miles away from a city that the driver tells officers they just left an hour ago. Also, if we look at other reasonable cases, like maybe this court's decision in Frazier case, I would submit there's less factors supporting reasonable suspicion here than even in Frazier. In the Frazier case, we had air fresheners, we had evasive responses from the driver. The driver produced 2 identification cards from different states. That driver was in a rental car traveling cross country. He was unable to produce the rental contract. And even there, this court found that there wasn't an objective reasonable suspicion of criminal activity.
How many minutes was this stop prolonged that you found objectionable from its inception? The additional.
Well, it's my position that there's no reason to stop the car to begin with, but it took about 10 minutes for this from the beginning of the stop until the warning was issued. After that, it was all extension, and it was all an unreasonable extension.
And how long was the
position?
How many minutes?
The video is about 22 minutes long, I believe. I may be wrong on that. I think another 12 or 14 minutes go by, somewhere in that range.
Before the consent was obtained?
The consent, there were multiple consents obtained, and I want to answer this question. I see I'm out of time. Initially, the Trooper Rule asked for consent to search the rear hatch area. It's a Jeep Cherokee. And so he searched that. And then as Mr. Munoz and his wife were standing on the side of the road, then he says, well, can I search the whole car? And I think it was just a matter of minutes before they requested to search the whole car. And they turned the car inside out. They removed the spare tire, bounced that, searched all through it. It took many, many minutes.
Your time's up, and I don't want to extend this much, but you didn't address the Jesus statute, the Jesus Malverde statute.
Sure, I'd like to talk about that.
Very briefly. I'll give you a minute.
Sure. There's other reasons than the protection of drug smugglers why someone might have that in their car. Here, there's indication it was for religious observance. The Malverde was displayed next to the Virgin Mary. So it looks like that was a religious symbol. Also, if we look at the Lopez Gutierrez case from this court that was cited by the government, in that case, there were multiple Malverde images in that car. There were hidden compartments in that car. There was air freshener, and there was not enough luggage for the long trip claimed by the driver of that. So we have much more attenuated circumstances here in that Lopez Gutierrez case. Thank you, Your Honor. And I see that I'm out of time.
Thank you. Mr. Buckman.
May it please the court, Albert Buckman, on behalf of the United States. I want to talk about the two independent bases for the stop and the extension of that stop. Kansas Statute 8-133 imposes two affirmative duties on drivers. One is to have a secure tag. The second is for that tag to be clearly visible. Here, the troopers stopped. They both testified they saw flapping of that tag to reasonably believe that the tag was not securely fastened. The video does not contradict that finding. The district court found the troopers credible in that testimony because the camera comes into play during the pursuit several minutes after the observations had taken place. Whether or not
Mr. Jackson said that the securely fastened argument was not preserved below. Would you address that?
I think it was argued by the government in their answer to the motion to suppress volume 1, page 90. The government states affirmatively Munoz's temporary tag was not securely fastened at the bottom of the plate after quoting the statute. But even if it wasn't fully argued, this court can affirm on alternative grounds that are supported by the record. Here, that ground is supported by the record. The district court found the officers credible in the flapping of that tag. And the question isn't whether the violation was occurring, it's whether they reasonably believed that the license was not securely fastened. And they did, and that was the first basis for stopping Mr. Munoz's vehicle. The second basis is whether he drifted outside of his lane, whether drifting on the fog line was sufficient. And again, the district court found the troopers credible. The dash cam shows what it shows. The district court found it grainy. It shows gross details. It does not capture fine details. And the troopers testified to as much, that it was older technology. The troopers observed Mr. Munoz drive twice on top of that fog line. If you think about it going 60 miles an hour, that would have been twice within 15 seconds. even fewer seconds if he was going faster.
Would that State versus Marks from the Kansas Supreme Court, would that be enough? I mean, it relies on the language as nearly as practicable. And here, there's no evidence in the record at all to talk about driving conditions. So it's hard to evaluate what was practicable.
I disagree. There was testimony of what the driving conditions was and the dash cam also shows those gross details of the driving conditions.
Well, the dash cam video, it's not going to win any Oscars.
It is what it is. But Trooper Rule did testify that it was light winds, 10 to 15 miles an hour. There was no snow or ice. It was a straight road. It was hilly. And the dash cam does show other vehicles maintaining their lane assignments. I don't think the dash cam tells us one way or another, but the district court found the troopers credible on that point. And it was not the district court found that the troopers were credible on that point. I'd like to address the extension of the stop. The troopers were, I agree that I believe the Rodriguez moment was the point behind the vehicle when Trooper Rule told Mr. Munoz, no ticket, just checking if you're awake and sober, and then continued questioning. That was the point when he needed reasonable suspicion, and I'm not arguing consent in this case. And that reasonable suspicion, that temporary detention, that needed to justify up until the point of consent. The Trooper Rule relied on 4 factors. Some of these factors kind of mixed together, but it's the Jesus Malverde observation of that pendulum. It's the physical nervousness that Trooper Rule observed of Mr. Munoz, the unprompted statement, as well as the unspecified travel plans. And looking at the totality of the circumstances here, I think everything needs to be viewed from the lens of that Jesus Malverde pendulum hanging. That informs the totality of the circumstances and why these troopers had reasonable suspicion that drug trafficking was occurring. So Trooper Rule articulated that this was extreme nervousness, but he provided a basis for that conclusion. He said it was not a normal traffic stop. He testified that Mr. Munoz's hand was shaking as he was handing the paperwork over. And even after he said no ticket before he went into the vehicle to do traffic stops, backing up, he said no ticket, left Mr. Munoz in his vehicle to go do the traffic checks, returned, and he stated that Mr. Munoz's voice was still showing nervousness. That shows that this wasn't just nervousness as any normal citizen encounter. It was persistent, and it was extreme to the point that it was showing physical manifestations. And Trooper Rule was thrown off by how Mr. Munoz just launched into his story, not in response to routine, and I have your driver's license and registration. Trooper Rule testified that this wasn't typical behavior. Most drivers, and this is based on his experience on those roads for 30 years, they typically ask, why did I get stopped? And Mr. Munoz launches right into a story. And Trooper Rule immediately felt that based on his training experience, which can be considered, that was, it was an attempt to evoke sympathy, which he had seen many times in his experience with drug traffickers. So that unprompted statement both showed the nervousness, but it also showed Trooper Rule that this may be an attempt to evade him, to evoke sympathy, and that's all building into the totality of the reasonable suspicion here. And he also found it suspicious, based on his experience with drug traffickers, that Mr. Munoz didn't specify where he was going. Where are you going? To Kansas. They're already in Kansas. He didn't specify the city, and he went so far as to articulate that drug traffickers often don't disclose their location. So some of the factors kind of blend together, but here there was extreme nervousness, and Trooper Rule articulated a more than sufficient basis, and the district court credited that testimony.
Should we give any any weight to the fact that there was no hanging bag for clothes?
I think this court, it's a consideration, and it's something that Trooper Rule testified to. I'm not saying it's the strongest factor here. I think it's just a consideration in the analysis. Society may have changed. Maybe it is things that some people would do, some people wouldn't, going to a funeral, but Trooper Rule stops cars every day on that highway. He stops people going to funerals. And in his experience, he would expect to see dress clothes, and he testified to all of that. It's a consideration. It's not the biggest factor, but it is a consideration in the overall totality here and how the story isn't quite making sense to him. And this is all in light of the Jesus Valverde pendulum that's hanging there. Going to the unspecified destination. It was Mr. Munoz just launches into that conversation, not in response to anything. Trooper Rule at that point was surprised, and he testified that he was thrown off. He started conversing about the funeral when he was trying to do his routine checks. And I already addressed that Mr. Munoz said that he was in Kansas and didn't specify location, but he also didn't have a good, clear timing of that funeral. And here, the consideration isn't whether each piece can be explained by innocent behavior, it's whether we can rule out a significant portion of innocent behavior. And here, adding everything together, that was informing Trooper Rule in light of the circumstances that this may be possible drug trafficking. The Jesus Valverde pendulum, this court has used that as a factor before in the reasonable suspicion analysis. And both troopers testified that in their training experience that this is known as, Mr. Valverde is known as the patron saint of drug smuggling. That Mr. Trooper Ranieri testified even further that he had seen roadside seizures with that image being displayed. And while there may be innocent explanations for that, that's not the sole question. And it can be more likely than not that it was innocent, but it's whether by a totality, it's reasonable for officers to believe that supplies reasonable suspicion. And here the officers believed so in light of all the circumstances. So the government does believe that there was ample factors here added together for reasonable suspicion. So I moved a little quickly through my entire argument. I want to go back and address this fog line issue of whether being on the top or whether this was minimal and incidental breaching of that statute.
Well, if we agree with you about the license plate, do we need to even reach that?
I don't think so. They're both separately independent bases. Either affirming on either of those bases validates the traffic stop here. But it was well argued by the defense that whether this is a minimal and incidental breach, and it is a bit of a novel issue of whether driving on top of the fog line is sufficient. So I agree that to supply reasonable suspicion, it must be more than minimal and incidental lane breach, and we do the two-part fact-specific inquiry of assessing the number of crossings, touchings, how far over, the timing of that, as well as the adverse conditions here. And Trooper Rule testified that it was twice on top of that fog line. Even on the dash cam, he advises Mr. Munoz, hey, you were over on top of that fog line. And as I said, it was within a quarter mile. It wasn't within a mile, 2 miles. It was within a matter of seconds that Mr. Munoz was driving on top of that fog line. And there's more than ample evidence here, and the district court agreed that the conditions couldn't explain sufficiently that drifting. It was a bright, clear day, and the video shows in as much that it was a bright day. No obstructions, just a normal driving day. In this court, the government submits that was sufficient. That was more than minimal an incidental lane breach. And the question, another, I think somewhat novel question, is whether driving on top of the line or over the line is required here. I relied on two cases, Marks as well as McGregor, to argue that driving on top of the line is sufficient. In Marks, the court says, we interpret the statute as establishing two separate rules of the road. The first requires a driver to keep entirely within a single lane. That rule is temporarily suspended when it becomes impractical to stay within the lane markers. So they do articulate that the lane is established by the lane markers, not the shoulder of the road. So the government, certainly the court needs to consider how far he traveled, he drifted out of his lane. But there is authority here to support that it's that lane, fog line marker itself that establishes the lane. So I have 1 minute left. It's the government's position that securely fastened element of duty of the license plate statute is an independent statute. It's in the plain language. Lopez Estrada considered only that section of the statute in affirming on the reasonable suspicion in that case, despite a clearly visible tag. So that was an independent basis, as well as the drifting of Mr. Munoz in that lane. I'm almost out of time. If there's no further question, I ask this court to please affirm.
Thank you, counsel. Any questions from the panel? Thank you, gentlemen. The case is submitted. Counsel are excused. We'll turn to our next case on our docket this morning. Mr. Acton will start.
Good morning, Your Honors.
Okay.
Are we ready?
Yes, you're here. Okay, let me announce the case. 24-2145, U.S. versus Jimenez-Marquez. Mr. Acton, you may proceed.
Good morning, Your Honors. May it please the court. My name is Gregory Acton. I represent the appellant, Octavio Jimenez-Marquez, in this case. And Mr. Jimenez appealed his conviction in this case because he was not given fair warning that what he was doing violated the law. Obviously, he did violate the law, but not this particular law, not 924C, which imposes an additional 5 years mandatory to whatever other sentence he might get for what he was doing that was in violation of law. The court will remember that Mr. Jimenez was at his mother's house with a pickup truck unloading personal items out of the back of the pickup truck, and because they had traced this truck as being stolen, law enforcement approached and they discovered that there were drugs in the cab of the vehicle, and as well as firearms. There was an assault style rifle in the passenger well, and a pistol under the seat, and there was next to a bag of drugs under the seat. But that pistol was unloaded. The ammunition it might have been able to be sorted through in a shaving kit bag in the back seat. But the point of all of this is that, I mean, he was a drug trafficker. He was in possession of drugs with the intent to sell those drugs. He'd been doing that. But what he was and he was in possession of firearms. But what he was doing was, at the time that this 924C was rewritten by Congress, When it was rewritten, Congress and everybody else knew what it meant to possess a firearm during and in relation to a drug trafficking crime. It was very clear. We have, to give an assortment here, the Muscarello case in 1998, the United States Supreme Court. We had a handgun locked in the drug truck's glove compartment and a bag, a firearm in a bag in the trunk of the car, but that was during and in relation to. The Bailey case from the DC Circuit.
Let me stop you. You made a very interesting argument, but isn't the issue whether in furtherance of is too vague language? And we have lots of cases interpreting that language, and it doesn't matter what in relation to means. We know that in relation to, or we assume at least, that in relation to covers more than acting in furtherance of or possessing in furtherance of. But as long as we have clear guidance on what in furtherance of means, why do we care what another provision means? I don't.
Well, it's the same provision, and I think we care because it's what Congress tried to do with this. It's what Congress after the Bailey case, U.S. Supreme Court case, said, you know, that you can't be having mere possession during a relationship to. If you have mere possession, Congress has got to put in the word possession. And Congress looked at that and said, okay, we'll put in the word possession, but we're going to separate possession out from during in relation to.
Right. But do you disagree that we have a fair number of cases that make clear what in furtherance of means in this context?
The problem with these cases is they don't define. It's not clear at all to me because they don't define the space in between in furtherance of and during in relation to.
Why do we care about that? If he knows what space is covered by in furtherance of, why do we care whether he knows or anyone else knows what in relation to means? He's not charged with that. Isn't he on notice of what can get him in trouble, what can get him criminally liable? I
think what puts him on notice should be determined at the time that Congress was writing this thing, because at the time because I think congressional intent matters.
Wait. No. There's a whole body of law that a court can interpret it more or less narrowly, and it's once it's been interpreted by the court, and there are lots of decisions saying this is what in furtherance of means, that's settled. It may not have been as clear at the time it was enacted, but the courts have interpreted it to make it clear. And I don't see what's unclear about the language in furtherance of. You make a good point that in relation to means something different, and you're curious about what that can mean. And that's an interesting argument, but I don't see how it has any relationship to whether in furtherance of is too vague.
Well, I appreciate that, Your Honor, because I think you're focusing on the real point here. Because I have been searching for to understand. I'm looking for an explanation here. I'm looking for why is it that if take the hypothetical drug dealer, who we have a long list of cases that if you have the fortress analogy from the Sixth Circuit, but if you're using a firearm just to protect your drugs, it's just there in the event that you need it, and now Congress is amending this, and okay, so now I know, because what Congress just wrote, that I can do that. I can do that. It's not that I may not be able to possess a firearm for some other reason, and I certainly cannot be possessing the drugs with the intent to distribute them and possess them otherwise. But the Congress has just told me that if that's all I'm doing, it's not an extra 5 years. And that's clearly what Congress was trying to do. And I don't think the courts are justified in ignoring what is the clear intention of Congress in amending this statute. And they have not actually addressed that. I'm sorry.
Go ahead, Judge McHugh.
The intention of Congress was upset with the court, thinking that they weren't enforcing it broadly enough. And so Congress went back in to give it greater reach, not less.
But Your Honor, then they narrowed it. They did greater they expanded by adding the word possession, and then narrowed possession from during in relation to. And no court has been able to explain the difference.
And in relation to, you can meet the requirement by just showing in furtherance of, right? So does your client have, first of all, you make a facial challenge, but you can't challenge a criminal statute facially if it doesn't impact First Amendment rights. Would you agree with that?
I do, Your Honor. This is really
okay.
more,
So we're talking about this as applied to your client. As applied to your client, as Judge Hartz has pointed out, we're looking at the in furtherance of language, not the in relation to. He wasn't charged with he was charged in furtherance of.
But Your Honor, I don't think that is fair to read a statute in parsing it that way, rather than reading it in context. I think that's the proper statutory interpretation, is to look at the language in the context. And you have to compare those two terms, those two phrases in this statute to be able to understand them. And that can't be explained. If that difference can't be explained, then it's unconstitutionally vague.
Is there any case that's found the in furtherance of vague?
I've not found cases arguing that.
How about the converse?
I'm sorry?
Aren't there cases that find this language is not vague?
Well, I think there are. But I don't think it's I don't think it's making the argument that I'm making, that they have, because yeah, when the courts say that that's not vague, they're saying, well, in furtherance of, we know what that means. But they never ever take on straight up what's the difference between those two, because Congress clearly intended a difference.
Well, let's start with that. So during and relation to is broader than in furtherance of. You agree with that?
Yes. Uh-huh.
So what you're relying on is that in the past, courts have found that during and relation to covers situations like the situation in this case.
Correct.
So why does that mean that it's not also covered by in furtherance of? The fact that the language before was broader and covered this doesn't mean that actions in furtherance of does not encompass what happened here. It could have satisfied the during and relation to and still satisfy in furtherance of. There may be other situations where it could satisfy during and relation to, but it wouldn't satisfy in furtherance of. But that's not the case we have.
But I can't find any explanation, even theoretical, as to what kind of facts fall in that space.
In what space?
The space in between those two standards. Congress said it's supposed to be a slightly higher standard. They're two different standards. They're not being treated as two different standards.
If this is an as-applied challenge, why does your client get to challenge that? Your client was convicted based on in furtherance of, and that's not vague.
I think it is vague if you're understanding which these are a criminal's understanding of the law is a fiction, right? But so using that fiction, we have a hypothetical criminal that understands the law and understands the jurisprudence underlining that, and looks at that amendment and says, I can do this because Congress narrowed it. It said that you need something more than just protection. That's what they say, because possession protection was during in relation to, and Congress said you need something more, and nobody can explain what that is. So all I know is if I just hold that gun for protection, I'm not violating that law. And if the law, and if the result is I am, then it's so vague because I can't explain how it's different.
It seems to me that in furtherance of is less vague or more clear than in relation to.
That gets us back to the same place, though. It's it's not necessarily that you can't just clearly define in furtherance versus in relation to. It's how in relationships is defined in the jurisprudence, and Congress saying we need to, if it's going to be possession, we need a closer connection, but nobody can define what that connection is. What is found in that closeness? What is the fact scenario that makes this closer than a possession for protection? Because possession protection meets the lower standard. How do you get to the higher standard?
So we've been at the same issue the whole time that you've been arguing today, but what you seem to be saying is we know that during and in relation to is broader than in furtherance of, and you want to know what the difference is. But as long as it's within the in furtherance of, who cares if during and in relation to is broader or how much broader it is?
Because it's not a lower standard, it's a higher standard.
During and in relation to is broader, is it not?
But it's a lower standard. I don't know if I'm following.
You mean you don't have to prove as much for that? So why do we care what more could have been covered if for possession?
It's like
during and relation. I'm sorry. Go ahead.
I think, as the government argued, it's the difference between preponderance of the evidence and beyond reasonable doubt. We all know that if you've got a preponderance of the evidence, that's not enough for reasonable doubt. And I think it goes that direction. I think it's like you can have enough for during a relationship too, but Congress intended that not to be enough. So maybe we're not using the word broad and narrow the same, but Congress intended that would not be enough because it is a higher standard. It's a closer connection. Mere possession for protection is not a sufficient connection. But what is that connection? I'd like to reserve the rest.
Why isn't that enough? I mean, our cases say that drug dealers carry guns both for protection from people that want to steal their drugs and money and to use offensively if they're of that type. So who cares if it's for personal safety?
I could argue the policy of it, but this is what Congress was intending when they wrote new words into this statute. They had some reason to put in furtherance of. All they had to do was say during a relationship too, and all of this would have been covered. Without wording, but they put in furtherance of, okay. And
I'm going to give you a minute to address your second issue, because I'm not going to let you wait until you hear from the government and then give rebuttal when you haven't said anything on direct. So 1 minute to discuss the sufficiency of the evidence.
Oh, Your Honor, I don't need much time on that at all. I think that the insufficiency of the evidence is a natural byproduct. I'm saying that you need some other kind of evidence to get you from the lower standard to the higher standard. Okay. And if we can't define what that is, we don't know what it is, we certainly didn't have it in this case.
Okay, thank you, counsel.
Thank you.
Mr. McKay.
Thank you, Your Honor. May it please the court, Lou Mattei on behalf of the United States. I want to start with what I think is the central theme of the discussion that we just had, and I think it really points to the key flaw in the defendant's argument. He's misunderstanding the relationship between in furtherance of and in relation to. I think it's clear from this court's cases that in relation to is a broader circle that we're dealing with, and that in furtherance of is a narrower subset of relationship within that broader circle. If we're thinking of it as a Venn diagram, in furtherance of is a smaller subset within in relation to. And so if as the court was indicating, the problem is with that broader outer reach of the circle of in relation to cases, those defects are not applicable to the in furtherance of scenario that we have here. This case was only charged as an in furtherance of case. It only went to the jury on that theory. And that's the only version of 924C that we have before the court in this case. And so even if there are theoretically some issues at the periphery of in relation to, those issues would not create a constitutional defect within the in furtherance of statute that we're dealing with here. The key misunderstanding I think that the defendant's brief makes is that in relation to and in furtherance of are two completely separate things. Really, the overlap here does not create ambiguity. And I've thought of, some analogies on this, but the one that I keep coming back to from popular culture is if we're on Family Feud and the category is green things in a forest, the top answer might be trees, right? That's going to be a pretty common subset of in relation to. But there are other green things in the forest. And just because trees might take up a large portion of the playing field of the in relation to space, that doesn't create ambiguity or any inability to distinguish between these two categories of things.
What's the point of having in furtherance of if it already is fully subsumed by in relation to?
Your Honor, I think the answer to that question really comes from the Bailey case and then Congress's response to it. When we're looking at the prior version of Section 924C, of course, pre-Bailey, it only criminalized use and carry of a firearm during and in relation to a drug trafficking crime in a case like this. And the problem that the Bailey court found is that courts had been construing use and carry to include possession for protection. The Bailey court says Congress knew how to criminalize possession, and here it didn't use that word, it used the word use and carry. And so to construe use or carry to include possession is a problem. And so in that context, all of those the pre-Bailey cases finding that possession for protection fell within that prior version of Section 924C, all of a sudden possession for protection was excluded from the scope of Section 924C. And so Congress acts to fix that problem. And that's where we have the current part of 924C that is at issue in this case. Congress amends it to add this new prong, saying that possession in furtherance of a drug trafficking crime is now back within the scope of Section 924C. And so it was clear that it was trying to correct the issue that the Bailey court pointed out. At the same time, it's long been a concern both of Congress and I think of the courts that we don't want to be criminalizing mere possession, where a firearm is just incidentally present during an underlying crime. That has always been something that's outside the scope of the statute, and that's why Congress here created this more strict intent element. The in furtherance of component was added to make sure that we're not criminalizing mere possession, incidental possession. And so it added...
To me, it still doesn't make it, you still have the first category completely covers the second, and all you had to do was put possession with carry and use, and it'd still be in relation to the drug crime. So it still doesn't, to me, explain why you have the separate in furtherance of that is completely subsumed under in relation to.
I think, in addition to the concern about criminalizing mere possession, I think there is some daylight between these two standards. So accepting the defendant's premise that we need to be able to clearly articulate some difference between the in relation to and in furtherance of standards, I think the cases actually do shed some light on that. The in furtherance of standard is supposed to mean or indicates that the firearm is going to help or promote or actively facilitate the underlying crime, whereas in relation to is broader in the sense that it includes even the potential to facilitate. And so we don't need to have actual facilitation. Even the potential of facilitation is enough during under an in relation to context. And there's a case
again under your Venn diagram example, the in furtherance of would be completely within inside the diagram of the in relation to, right? I mean, so aren't we interpreting in a way that makes in furtherance of surplusage?
Well, I don't think so, because if we take the Venn diagram example where on this intent component, the in furtherance of is completely contained within the in relation to universe, they're paired with different act elements, right? And so the carrying and use is a narrower act component that is then paired with the broader intent component under that prong of the statute. Whereas on the act side for possession, that's going to be much broader and every possession is going to include using or carrying. And so we have this sort of inverted relationship between the act component and the intent component. And I think that shows
why would the government ever charge in furtherance of when they could make it easier on themselves by charging in relation to?
Well, I think the answer to that is because not every case is going to have the using and the carrying in a provable way. Possession as a much broader category of act.
Give me an example of that.
Well, I mean, I think there's some good example in the case law, actually. So the Combs case, which is not, I don't think it's cited in our briefs, but it's discussed in this court's cases on this topic. They give examples of a drug dealer who, or a drug buyer who goes to the dealer's house and surreptitiously steals the dealer's gun. Or there's the Schuler case from this court talking about firearms that were stolen as loot of the robbery. And so firearms in that context are possessed. Those firearms are in relation to the underlying crime, but they're not being used to facilitate or to further the underlying crime. And so I think cases like that really illustrate the space between these two standards in a way that, even if it isn't a ton of space, there is space there. And I think there is logic to Congress crafting the statute in that way.
I know there's space. Why do you make it harder on yourselves by charging in furtherance of?
Well, I think the answer to that in a case like this is because we have solid evidence of possession, but we don't necessarily have using and carrying. Like this defendant here, clearly possessed the two firearms at issue. He was in the driver's seat of this truck, and right underneath that seat was one firearm, and within arm's reach in the passenger seat was a loaded rifle. He clearly possessed those firearms and admitted to police that he had moved the rifle. And so possession is easy to prove there. But we don't necessarily have using or carrying those firearms other than the mere act of possession itself.
Let me see if I'm understanding the history correctly. The statute that was addressed in Bailey, covered using or carrying a firearm in relation to during and in relation to a drug trafficking crime. The Supreme Court said that language doesn't cover possession. You have to be using or carrying it. Just possessing isn't enough. So Congress could have changed the statute to prohibit using, carrying, or possessing in relation to a drug trafficking crime, but possession never appeared in the subsection, the during and relation to. Instead, they added to the charge to the prohibition on using or carrying a firearm in relation to a drug trafficking crime. They added a second, possession, but only possession in furtherance of a drug trafficking crime. So it's not like the government here could have prosecuted him for possessing a firearm in relation to a drug trafficking crime. There's no statutory language allowing that. Is that fair?
That's correct. That's absolutely correct, Your Honor. There is no prohibition on possessing in relation to an underlying crime. And so, really the modified or the current version of Section 924C sets out these two separate avenues that the government can pursue, either using, carrying in relation to the underlying crime or possessing in furtherance of. And so I take the court's question to perhaps be aimed at the idea of why did Congress add this different intent component, the in furtherance of component, when it wanted to address the possession for protection scenario. And I think the reason it did that is, as I indicated before, there is concern about criminalizing innocent mere possession of a firearm. And the classic example of this in the case law is the drug dealer who has a stash of drugs in his house and has a firearm, a hunting rifle that's unloaded, locked away in a closet during a drug deal. And so, it's hard to say that firearm is used or has some kind of strong nexus to the drug deal if it's an unloaded hunting rifle that's locked away. Similarly, this court's cases, like the Island case, for instance, and even the facts of Bailey to a certain extent, talk about, the proximity and accessibility of the firearms. And so when these firearms are stored in a way or possessed in a way that they're not readily accessible or proximate to the underlying crime, Congress wanted to be careful about not criminalizing scenarios like that. And I think that really leads into the sufficiency argument here, and I'll spend just a few moments discussing that. Of course, I welcome the court's questions on any of the issues we're talking about, but the sufficiency of the evidence here, I think there's no real question or no real doubt that the firearms in this case were possessed in furtherance of the drug trafficking crime. It's important to point out, I think, first, that the defendant doesn't challenge the underlying drug trafficking activity or the conviction for possession with intent to distribute methamphetamine. And so when we start applying the factors that this court has created from the Basham case going forward to analyze whether we have possession in furtherance of a drug trafficking crime, those factors all weigh in favor of the conviction here. The two primary ones are the proximity and accessibility of this defendant's firearms. I mean, this defendant had a revolver right under the driver's seat where he was seated, right next to a large package of methamphetamine, the rifle, which was loaded in the front passenger seat within arm's reach of where he was seated. Again, that's clearly distinguishable from the facts of a case like Island or a case like Bailey, where the firearms are stored some distance away or locked in a separate storage compartment away from the drugs. That's not the facts that we have here. I think on top of that, we have a strong factual context in the time and circumstances underlying this particular defendant's possession of these firearms. There were text messages that the jury saw indicating both that this defendant had been asked by drug trafficking associates for firearms, and then more to the point, that he himself had been the subject of a drug-related robbery where he's indicating text messages, and this is in the record at volume 3, 356 to 358. He's receiving text messages or sending text messages saying that his storage of drugs had just been stolen and he needed some straps or some firearms to fix that situation and to protect himself. And so we have specific evidence of this defendant's particular intent with these firearms, that he obtained them in response to being robbed of drugs himself. And so the time and circumstances of this case strongly indicate that in furtherance of nexus. Of course, the type of activity here, drug trafficking with, over 500 grams of methamphetamine, there was testimony that it was worth, at least up to $10,000, something that a drug trafficker would certainly want to protect. And then there was testimony about how each type of firearm in this case, both the revolver and the rifle, had particular advantages to drug traffickers, either in the case of the revolver, concealability, or in the case of the rifle, a longer range and the ability to store additional ammunition beyond what a revolver could hold. The last two Basham factors here, the legal status of these firearms, this defendant was not legally permitted to possess any firearms because he was unlawfully present in the country. On top of that, the revolver had been reported stolen. So both of those factors weigh in favor of a finding of that in furtherance of was satisfied here. And finally, the defendant makes a point about the revolver being unloaded as compared to the rifle, which was loaded with 2 rounds of ammunition. But there was expert testimony in this case that even an unloaded revolver could be used to achieve the purpose of protection, for the simple reason that the person on the other side of that firearm is not necessarily going to know whether it's loaded or not. So if we're looking at the objective of protecting the drug trafficker, that can be achieved whether the firearm is loaded or not. That protection goal or component is only strengthened in the case of the rifle, which actually was loaded, could have easily been used to actually fire a bullet. And so I welcome the court's questions, if there are any.
It looks so. Thank you, counsel. Case is submitted. Counsel are excused. And we'll turn to our next argument. Looks like we're all here. We'll turn to 24-1331, U.S. versus Becker. Ms. Torin J. I hope I got close to that at least. You may proceed.
Good morning. I'm Perrin Toronjo on behalf of the appellant, Mackenzie Becker. This case asks whether the Fourth Amendment permits police to search a home for evidence of a road rage incident simply because they had seen the suspect in his car there. 3 weeks after a road rage incident on I-25, police sought a warrant to search a house on Iliff Lane, thought to be associated with the suspect, Mr. Becker. The affidavit recounted that Mr. Becker's car was parked at the house 2 weeks after the incident and that he was seen washing it there roughly 1 week after that. But beyond the presence of Mr. Becker and his car at the Olive Lane house, the affidavit contained no facts suggesting that evidence of the road rage incident ever made it to the house, let alone remained there at the time of the search. Because the affidavit provided no factual basis for believing that the Olive Lane house was more likely than the otherwise endless possibilities where the evidence could be stored 3 weeks after the incident, as the affiant himself acknowledged, it clearly fell short of establishing the probable cause nexus required by the Fourth Amendment. We therefore ask this court to reverse. Turning first to the probable cause question. We argue the affidavit did not supply probable cause because it contains no facts connecting the road rage incident to the Olive Lane house. First,
is there any question about Mr. Becker's relationship to the Olive house? I mean, are you challenging the fact that he might have lived there or had some interest in that home? Because they did have some information from the crime database that he had lived there, or at least listed that address. Are you challenging that part of the affidavit?
Yes, Your Honor. We are challenging the probable cause to believe that the Olive Lane house was Mr. Becker's residence. We agree that there was obviously some association because his car had been seen there once and he had been seen there washing his car once. And there were unidentified police records that said it was a second address attributed to him. So we can see that he was associated with the property, but there's not enough evidence to say that this was his residence.
Does that matter?
Yes, I think it matters. It matters, and yet it's not the core inquiry. The core inquiry is whether there's enough connecting the crime to the place to be searched. But I think residence is relevant. And so the fact that there isn't an established residence undermines any inference that the gun would be found at this particular place. But if the court finds this was Mr. Becker's residence, that doesn't defeat our argument because this court has consistently said that simply a probable cause to arrest a person or that they've committed a crime does not get you into their house for a search. So it's relevant, but it's not the core inquiry.
Does it matter that what the item is they're looking for? I mean, as opposed to say drugs, we're looking for a gun. And there was evidence that people tend to treat those differently. That they, as a general rule, don't throw them away or flush them down the toilet or consume them, and they tend to keep them in their homes.
Your Honor, just to be clear, the only statement in the affidavit regarding the gun and kind of typical patterns around guns was Detective Sloan's statement that people do not typically dispose guns after a crime. He didn't say they typically store them in their houses, and this is not case specific. So that's a very generic statement. And this court said in Mora that those types of training and experience statements need to be tied to the facts of the case in order to have any weight. And here we don't have a statement that, people don't tend to dispose of guns even when they're used in public altercations where there's a serious risk of detection. That would have been a clearer statement, but that's a highly generic statement. And even crediting it, it says nothing about where that gun is going to be. And that's the core inquiry. And this court hasn't relied on such generic statements in establishing probable cause before.
Do you need to show that the gun was going to be at that place? What if there's several places he frequented? He stayed at his girlfriend sometimes, stayed at his home, maybe stayed with his mom. Say you identified the 3 places where he stayed. Wouldn't there be probable cause for each of them?
I think that there could be, Your Honor, yes. So I think Roland answers this question is there's no nexus if given the facts in the affidavit, the evidence could be in any number of places, and there's no factual way to limit those places or to suggest that the home is more likely than any of the other places. Here, that's what we have. We have no facts.
I think you interpreted me to say the opposite of what I meant to say. Oh. You don't have to show that it's more likely than not that the gun is at this one place. If there are 3 places where he might keep the gun, you'd have probable cause for all 3. Couldn't you have a probable cause for all 3?
Yes, Your Honor.
If you can't say this is the place he always stays, then there's not a probable cause. But I don't think that's the test.
Yeah, I think I agree with you that there can be probable cause for multiple places. Of course, it's a threshold inquiry rather than the police don't have to eliminate every other possible location. But I think the language in Rowland, and I'll pull it up.
Rowland is a very different case. I mean, first of all, we're dealing with child pornography, and the analysis was that there was an almost unlimited number of places where that could be, right? I mean, we don't have a situation here where there's an almost unlimited number of places, do we?
I think we do, Your Honor. And I think the affiant himself effectively says that when he says that the gun could be found in any location or vehicle that's associated with Mr. Becker. That's a nearly unlimited number of places. And the affidavit doesn't provide us a factual basis for limiting that unlimited number, which is what is required. And I think the facts of Rowland are relatively pretty similar, even though, of course, we're dealing with child pornography. But first, in Rowland, the officers knew generally that he had ordered child pornography to be delivered to a post office box and that he typically would take the mail and go back to work. But what the affidavit was missing was that whether he would drive directly to work or stop somewhere else, or that he would typically take his mail there. And here we have that Mr. Becker has visited a house that he may or may not live at. But we don't know, just as in Rowland, we don't know whether he drove directly from the incident or even in days afterwards to that house. And so we're missing that same sort of connection between how the evidence would arrive at the house. And then we have the additional problem that we're 3 weeks later. So Rowland all of this happened the day that the child pornography videotapes were delivered. Here we're 3 weeks after the incident, and we don't even have that inference that, I mean, it's pretty reasonable to think that after someone goes to work, they're going to return home and probably that they will bring their mail. Here, there's no inference that Mr. Becker went to the Iliff Lane house at any point until 2 weeks later is the first time that police see him there. So I think this case is actually a lot like Rowland. And just on a kind of gut reaction, it seems that a gun could be in many more places than child pornography videotapes. Personally, it just seems more likely that someone would bring those home than a gun that's been used in a public altercation.
What about good faith? I mean, even if
let's talk about good faith. I think
why wouldn't we be able to affirm under good faith?
I think there are 2 core reasons. First, that there is no facts connecting the crime to the house. It's devoid of facts connecting crime to the house. Unlike court cases like Cotto, where this court is upheld on good faith. Here we have nothing connecting the crime to the place. And on the face of the affidavit, the officer acknowledges that they don't have a nexus. He says the gun could be.
What about the car? The car matches the description that the victims gave, and it has the license plate on it that matches what the victims said. It's associated with Mr. Becker, and it's parked in front of the house. He goes in and out of the house repeatedly while he's washing it. I mean, doesn't that connect the crime to the house?
I don't think so, Your Honor. I think all it does is connect.
I mean, the car was used in the crime.
I see the car. To me, I think the car says nothing more than his being there. He's using, just as we all drive around in our cars, the car being at the house says little more than he was there 2 weeks later. And I think
what you said is there's no connection between the crime and the house. If the car was an instrumentality of the crime and it is parked in front of the house, isn't that a connection between the crime and the house?
I don't think so, just given the nature of I think because we all have to drive around in our cars, and there's really no, that would be.
But we don't have to drive around in cars that were used in a violent assault. I mean, and that's the issue here. I mean, if there was a bank robbery and it was the getaway car and it was parked in front of the house, do you think there would be probable cause?
I think it would depend on when it was parked outside of the house. I think that's the core problem here. Is in Kodo, the suspect effectively drove to the house to be searched. He may have stopped somewhere else, but it appears he drove there and then he was seen returning within hours. And that temporal connection is what actually makes the car a reasonable basis to think that there's the gun was going to be at that house. Whereas here, the first time the car is seen at the house is 2 weeks later. And so I think that is not a significant.
It was seen though, as quickly it took time to develop the evidence that would link Mr. Becker to the shooting. So, I mean, that's kind of as soon as they found the linkage, they staked out the house, right?
I'm not sure that's how the timeline worked. I don't think they give us the date when they are actually looking up the records, but I'm pretty sure by the 14th, so the day after the incident, they had figured out that Mr. Becker was the one who was registered to that car. And they didn't stake the house out until 2 weeks later, at least according to the affidavit. So I think police had a couple of options here. They could have immediately started staking out the house as they did in Kodo. In Kodo, they immediately figured out who was driving the car and they went to the place where the car was registered, that Apodaca house. They could have done that here within at least a day. Sure, maybe they couldn't have done it the day of, but at least a day. Or they could have taken these 3 weeks and actually developed a connection to the house. They could have done trash pulls. They could have interviewed the neighbors and said, have you seen anything weird happening here? They could have done an overnight surveillance. There are a number of things that they could have done with those 3 weeks. I don't think we're asking for perfection from officers here. We're asking for moderate efficiency or using the time that they have to develop a nexus. So Your Honor, I think that there were plenty of options for them. I think unless the court has further questions, I'll reserve the remainder of my time.
Okay, thank you. Mr. Houlihan? We're not hearing you, Mr. Houlihan. Can you unmute?
Apologies. Good morning, Your Honors, and may it please the court. My name is Michael Houlihan. I represent the government in this matter. The question presented by this appeal is simply whether the affidavit supplied the additional evidence needed to connect the road rage shooting under investigation or the evidence of that crime with the location to be searched. The warrant here clearly did so. And to illustrate the point, I'd like to start by highlighting the items that were to be seized pursuant to this warrant as they help to elucidate the larger probable cause narrative. In the main, the warrant sought to seize 3 items: the defendant, the alleged perpetrator of the road rage shooting under investigation, the defendant's vehicle, one of the 2 primary instrumentalities of that crime, and firearms and associated items, the other primary instrumentality used in that crime. There is no meaningful dispute that the warrant provides probable cause to believe that the defendant committed the offense under investigation, or that the warrant adequately detailed its basis for believing that both the defendant and the vehicle could be found at the Iliff Lane location. In other words, the warrant had already supplied a basis to connect not only the defendant, but one of the 2 major instrumentalities of the crime to the Iliff location. Those facts, combined with the affiant statement as to where the firearms evidence would likely be found and why, supplied the additional evidence needed to establish a substantial nexus between the evidence sought and the Iliff location. And some of this court's prior precedents make that point very clear. Beginning with Ron, this court approved of a warrant to search a residence based on PC that was between 10 and 18 months old, and which did not place the firearm to be seized within the place to be searched. In doing so, the court expressly acknowledged that there were other places the gun might have been stored, but upheld the magistrate's reasonable inference that the defendant's residence might be one such place. Now, the defendant has tried to distinguish that case away by saying that it turned on, quote, case-specific facts, unquote, connecting the guns to the residence. But in truth, those case-specific facts were simply facts about why the defendant had the guns, for hunting or for investment,
and natural inferences drawn by the court about where guns possessed for that reason might be stored. The same is true of the affidavit here. The affidavit spells out probable cause to believe that the defendant possessed the gun and used it in the crime, the road rage shooting at issue, and then makes explicit the inference that guns possessed for criminal purposes would usually be kept with the defendant or in his vehicle, drawing on the...
Let me test that a little bit. I mean, this is a defendant, he's got outstanding warrants and has just committed a very public gun crime. I mean, it seems to me the smart thing would be to toss it out your window on the way home.
And I think, Your Honor, that would have been another fair statement by the affiant if he said, in my training and experience, people who use guns in crimes often toss them out the window or throw them in the trash. But the affiant made the statement, a factual statement based on his own training and experience, that that's not what happens. And so gave the court, the reviewing magistrate judge, a basis for concluding that the firearm would still be with the defendant or in the vehicle used in the crime. And so just closing the loop on how this does compare with the case in Ron, I'd say the case-specific facts do exist here. This is an affidavit saying this gun was used in a crime by this individual and in this car, and then spelling out the additional evidence that the affiant says guns that are possessed for use in a criminal purpose are often kept with that defendant or in their vehicle.
Do you think there was probable cause to search the Parker Roadhouse?
Your Honor, that would have been a closer call, I think, based on what the affidavit discloses about the nature of that location, that when the officers arrived there, they found that there was one vehicle. It didn't appear to be the vehicle that was used in this crime. It appeared to be abandoned, and then they had traveled to a second location and seen the defendant and the vehicle in a manner that was consistent with residence or at least presence in that second location at Isla. So I think that the affidavit, if it had sought to search the Parker Road location and disclose the same facts, it would have been a much closer call. But I think the combination of factors that we're seeing in the Isla Road location gives a clear basis for thinking that that is a location where the defendant might be found. And Your Honor, on that point, I noted your question about the relationship, or whether the relationship between Mr. Becker and the Isla location is contested. I just want to re-highlight some of the data points that do support the relationship between him and the Isla location. First, there is the law enforcement database that associated defendant with the Isla location. I'll come back to that in just a moment. Second is the presence of the car that was used in the crime, and it's depicted in two different photographs on page 7 of the warrant, where it is parked very tight to the garage at Isla Lane. And third, there was the sighting defendant himself walking in and out of the location, in and out of the car, and later hand washing the car in the driveway. In addition to the points that are made expressly, the facts that the warrant supplies support the magistrate's reasonable inference that defendant resided at that property. For instance, the location of the vehicle as depicted in the warrant is telling. In both of the two pictures on page 7 of the warrant, the car is parked immediately up against the garage at the end of what appears to be a medium-length driveway set away from the road. The reviewing magistrate might well have drawn the reasonable inference from that placement, along with other facts in the affidavit, like the defendant walking in and out of the house and washing the car, to conclude that he was, at least at the time of the warrant's execution, residing within that location. Regarding the database check, defendant has made much of the point that the database was unidentified, and I would concede that under Roach, that entry enough would not be alone to support a substantial nexus. However, in this case, it did not stand alone. The officers documented...
Sorry, I'm sorry. What did you just say? In this case, the database was not what?
The database did not stand alone. Okay. It was the facts that are contained in that database are corroborated by officers' direct observations. And in light of that corroboration, the database entry takes on additional value. It tends to support the determination in the magistrate's review that the defendant had an established connection with the property prior to the documented observations contained within the face of the warrant. As an aside, I'm primarily going to be focusing on the probable cause determination here, but I would note that the court in Roach found that even the unadorned reference to a database check in a warrant was sufficient to overcome the minimal nexus hurdle for good faith. Finally, I want to address Judge Timkovich, your follow-up point, whether or not it does matter that whether or not this Isle of Layton location was where Mr. Becker resided or simply where he could be found. Because it is clear under this court's precedence that whether or not a location is or is not a defendant's residence is neither necessary nor sufficient to establish probable cause to search for firearms. So while cases like Al-Qatani and Ron made clear that the defendant's residence was an important factor, it was not the only factor. What matters is that the affidavit establishes the additional evidence linking the crime under investigation or evidence of that crime to the particular location to be searched.
What about the temporal issue, that it's 3 weeks after anybody's seen this gun?
Well, there, Your Honor, I think that the primary answer on the face of the warrant is supplied by the affiant statement that firearms are not the type of evidence that one is likely to discard, and so they would be kept with Mr. Becker. And both because the court is entitled, the magistrate judge was entitled to rely on that statement, and also draw from their own reasonable inferences about how this firearm had been used. For instance, that Mr. Becker clearly had it on him at the time of the road rage shooting, immediately next to him. I don't think it was unreasonable to say, well, 3 weeks later, it might be in the same position. And if we looked at that question only as a matter of good faith, I noted the court's questions about the time length in Kodo, for instance, where it was a matter of hours. But I would direct the court to the discussion within Kodo, distinguishing cases in which no good faith was found, Gonzalez and Dutton. In distinguishing those two cases, the court took note of only two facts. One, the presence of the car that was used to flee from the scene of the road rage shooting in that case, as well as the defendant's physical presence. On those facts alone, not noting the duration of time or lack thereof, the court found there was sufficient basis on the face of the warrant to clear the minimal nexus hurdle. But again, looking at cases like Ron, for instance, where there had been a 10 to 18 month gap in any of the probable cause and no showing that Mr. Ron had ever possessed the firearms in the house, the court still found there was sufficient basis based on the nature of the items possessed, as well as some of the facts around why Mr. Ron possessed those firearms, to conclude that there was still probable cause to believe they were in the location to be searched. I'd also like to briefly discuss the challenge statement and the comparison between the affiant statement in this case, that the firearm is not usually disposed of following the commission of a crime, and defendant's characterization of that statement as conclusory. Simply put, the government doesn't agree that that is a conclusory statement. It states its conclusion that the firearm is still likely to be found in any location or vehicle associated with Becker, but then supplies the basis for the assertion. The affiant statement, drawn on his own training and experience, that a firearm is not normally disposed of after the commission of a crime. I agree that there was a somewhat similar statement within Mora that this court disapproved of, but there I think the question was not simply the fact that the affiant statement stated what would usually happen with evidence, but also posited the existence of evidence which was otherwise not found on the face of the warrant. The court took issue with the fact that in that case, the affiant stated that there would be a cell phone based on their training experience and that it would be found in the house. There were no facts to support either of those 2 points. The distinction here is that there is probable cause to believe both that there was a firearm and that it had been in Mr. Becker's possession prior to the search. The other case that I wanted to highlight in that regard is this court's decision in Harris, in which the court approved of an affiant's assertion that individuals connected to a violent crime or conspiracy are known to sometimes hide incriminating evidence at a friend's place or keep it at a common clubhouse. So that case, there was other evidence that established the nature of the location to be searched and the connection between the driver, who was under investigation at that time, and this ostensible clubhouse. but it was the affiant statement of opinion as to where evidence might be found that was the linchpin of the nexus in particular. So stating that otherwise, knowing that there is a clubhouse in which evidence might be stored 18 months after the fact of a crime does not actually establish a nexus between that 18-month-old crime and the location to be searched. It was only the affiant statement that, bless you, Your Honor. It was only the affiant statement that the evidence of that 18-month-old crime might well be found within this particular clubhouse that established the nexus required to search for that evidence. So consider the analog of that statement here, where the affiant provides probable cause to believe the location is defendant's residence, or at very least the location where he might be found, and then asserts that firearms are often retained with an individual following their use in crime. So viewed in that light, the statements accomplish largely the same purpose. They connect a location characterized by other evidence in the affidavit with the evidence that has been sought by the warrant. With that, I see I have 2 minutes left, Your Honor, but I will take any questions the panel has, but otherwise ask that the court affirm the decision below.
Questions? Thank you. Ms. Torrejo.
Thank you, Your Honor. Just a few points. First, it cannot be the case that probable cause to find Mr. Becker or his car at the residence equals probable cause to find evidence at the house. That would be true. That would have been true in Roland. And in any case where you know that the defendant lives somewhere or he might live somewhere. So I just want to say that cannot be the case. Second, Ron is completely different from this case and actually shows what the affidavit is missing here. In Ron, there were case-specific reasons to think that the gun was going to be at the house and was going to be kept there over time. The the conspirator had said that he wanted to let the guns appreciate. His co-conspirator had pawned the guns, whereas he had not. They looked at pawn records and he had not. He had used one of the guns hunting for personal use, and the court said, okay, well, if you're using them for hunting and personal use, more likely to be at a home. And he was an ATF agent, so he couldn't be storing them at work. And the fact that he was going to let them appreciate made it seem like he was going to give care to their storage. So all of those are case-specific reasons to think that the gun was still at the house. Ron is completely different from this case. Third, the officer's generic statement about guns not typically being disposed of after crime, it does not support probable cause under Mora. It is boilerplate. It's generic. It is not tied to the case-specific circumstances here. The court, as Judge Timkovich said in his concurrence in Mora,
why was it more likely that he would dispose of it here?
Because it was used in a crime that's public, where his license plate number is tied to that car. As the court in Wilson said,
so you would say the likelihood is very great that he would dispose of the gun right after the incident, maybe while he's driving away, toss it to the side of the road. Because now we're talking about a couple weeks later and nothing's happened to him. So it's not like, so if he was going to dispose of it, for the reason you say, he would dispose of it immediately afterwards. So if they went to his house, wherever that was, the next day or later that day, you wouldn't have probable cause to look for the gun because it'd be so likely he would have disposed of it beforehand. Is that where your argument takes you?
I think they would need some reason to think that it came back with him. Any evidence that he was taking things that could hold a gun in and out of the house. There's nothing like that here. Or even just if it was right afterwards, okay, maybe there's a good chance. But I think there's nothing here connecting the gun to the house 3 weeks later. We'd ask this court to reverse. Thank you.
Thank you, counsel. Case is submitted. Counsel are excused. So we take a break now or go another one? Is it okay to take another case, or would you rather?
I'm good either way.
Let's keep going.
Okay. Take our next case on our docket. As soon as I see. Okay, we're all here. We'll now hear 24-2128, U.S. versus Ruiz. Ms. Edelman.
Good morning. My name is Violet Edelman and I represent Joel Ruiz. I would like to reserve 2 minutes of my time for a rebuttal. I raised 3 issues in the briefs, and for purposes of this argument, I plan to focus on the insufficiency of the evidence to prove Mr. Ruiz's non-Indian status. Now, this court's recent published decision, very recent, in Hebert is directly on point and compels the outcome in this case. Because there is even less evidence in this case than there was in Hebert, the evidence here is clearly insufficient. Now, the government in its 28J letter strains to distinguish Hebert based on the officer's testimony in Mr. Ruiz's case about their training and experience in determining Indian status, which the government says means that their conclusions about Mr. Ruiz's lack of status meet the elemental requirement. But that simply can't be, because it doesn't change the content of the testimony and the evidence in the case. The testimony about their experience in Ruiz's case actually undermines the government's argument, because it primarily establishes that they didn't take any of the steps that their training and experience directed them to take. So as in Hebert, the testimony only reveals what they did not do in their investigation. They did not talk to Mr. Ruiz about his status. They did not talk to anyone who knew Mr. Ruiz about his status, and they didn't check the rolls of any tribe.
Do they have to check the rolls of every tribe? Every tribe in the continental United States and outside?
No, we know that.
I understand this is our rule, and I think Hebert is very good for you. But, most other circuits treat this as an affirmative defense. And it seems to me that the person who has the control of the evidence of Indian status is the defendant. So I recognize that Hebert is a published decision. It relies on other law from this circuit. But boy, you're asking the government to prove a negative, where in order to get the proof, you say, talk to the defendant. What possible motivation does the defendant have to help the government on this factual issue? So anyway, I guess I'm venting a little bit. I think our rule's a little silly.
Well, I have a couple things. I mean, first, this court is bound by Hebert and the cases before it, Prentice and its progeny. So this panel can't eschew that binding precedent. I think Prentice is well reasoned. It offers up a thorough interpretation of the statute, and when you have something like this that is a jurisdictional element, it's not. I don't know that there's any affirmative defense that's a just jurisdictional element.
Well, that's the issue, isn't it? Other circuits don't treat it like a jurisdictional element. They treat it as an affirmative defense.
Well, it is a jurisdictional element because it goes to the federal government's power to prosecute crimes in Indian country, and it's based on tribal sovereignty interests. But I'd like to go back to just the question about whether it's an impossible standard for the government to meet. And it's not. I think we have two cases here where the government, the officers, did not conduct a thorough investigation. And, it's true. We know from case law they don't have to check the rolls in every tribe. But there are rolls you could check based on the steps that they did take in their investigation, and that might suffice. You could say, okay, he lived near Jicarilla Apache for most of his life, and the victims are members of the Caddo Nation in Oklahoma, and he's born in Mexico, so let's look at the Tohono O'odham tribe and check those three tribes, right? And then that could be enough for the jury to infer something about tribal status because it ties into...
If that was what was done, you would be arguing that was not enough.
That's not what was done.
If they had done those three things, you would have said, look, there are 570 other recognized tribes, and you don't even have to be a registered member if you're to be connected with the tribe for purposes of Indian status.
Yeah, and if they looked at 10 tribes, you'd argue that that's not enough.
I might be making arguments to fulfill my duty to represent my but we'd be having a very different
and as well you should.
I think that there's a clear test from Prentice. There's two things that go to Indian status. There's ancestry and there's recognition by a tribe. And then there's a framework that's now crystallized in Hebert for looking at recognition. And there are certain questions that an officer can probe. Enrollment is one of those questions, but there's also other things. So I think if you talk to people who knew the defendant, people who know a person well would know whether they receive tribal benefits or participate in tribal life or are enrolled. I think that it's not a difficult burden. It's something that the government didn't carry.
You're not familiar with the facts in Hebert if you think that there were all sorts of opportunities. Hebert says this was not shown, all these things weren't done, but it's really hard to see how they could have been done in that case.
Well, and I think that's because perhaps they couldn't prove that element. When you have somebody who has lived on tribal land, it becomes a genuine question. And so then it goes to jurisdiction. But I think in Hebert, if that one woman who testified, the stepdaughter, seemed like someone who couldn't actually testify with personal knowledge, to the fact they could have asked someone else. They didn't. And the really important point is that there was no one like that in this case who testified. There was no one who knew Mr. Ruiz or testified to their familiarity with Mr. Ruiz and testified about his status. And there were people who could have done so. So, right now it's the government's burden to meet this element. And all we have is like one sort of tangentially related fact about his birthplace. So, I mean, I think even in Hebert, there were other things, like the officers in their testimony said, I think they said, we didn't ask, he didn't say he was not Indian. And we checked with 5 tribes maybe, but no testimony about whether they heard from those 5 tribes. So Hebert might have been different if the officers testified to hearing back from the 5 tribes in Oklahoma and they all said no. I mean, at least then there would be...
Well, you face that same issue in the Indian Child Welfare Act. I mean, what do you do if the tribe doesn't respond at all? I mean, you are absolutely right. We are bound by Hebert. That case is very good for you. And frankly, there were problems in my view, with how this was done even before Hebert. So, but yeah.
Let me ask you, Ms. Edelman, this panel may be bound by Hebert and Prentice. The court is not. The court could overrule that. Is there any reason why we couldn't overrule that in this case? Then I think we'd have to send it back for retrial, because I would think so, because the defendant didn't know it was an affirmative burden on him to prove Indian status. But how do you respond to that, to this court ending up reversing in this case, but allowing a retrial based on the court, not this panel, overruling Prentice and Hebert?
Well, I would return to the thorough reasoning offered in the en banc decision in Prentice. The wording of the statute does make it jurisdictional, even if it's an exception, which I think is sort of the reasoning offered up by those cases that make it an affirmative defense, and Judge Hartz, in your concurrence in Hebert. There's other case law that says if it's so closely intertwined with the definition of an offense, it has to be treated as an element. And that's what we have here. I mean, we have a statute that makes the non-Indian status of the defendant a feature of exercising federal jurisdiction. And if that is not what Congress meant to do, or if that's something that needs to change, then it's Congress's place to make that decision, not an appellate court. to define the elements of a federal offense. There's also history of the statute where Congress added, deleted, and combined and separated the jurisdictional limitation paragraph with the first paragraph many times. So the parallel construction isn't compelled by the wording of the statute or by the history. I don't know. First of all, I think proving a negative, we know it's slightly more difficult, but it's not impossible. And there are other statutes where the government is required to prove a negative, like in 1326, which I think constitutes at least our district's largest volume of cases, and maybe the largest volume of cases in the country. And there are other statutes listed in the Hebert opinion in, I think.
I'm sorry, what's the negative that has to be proved under 1326?
That a person lacks authorization, I think, unlawful reentry, so they aren't authorized to be in the country. So you have to.
But that's. It's been a while since I've had one of those cases, but I thought you check the government records and there's no evidence of. Someone can say there's no government record of that. Isn't that all that's necessary?
I think that's true, but you'd be checking databases that directly pertain to the question. That's different than what was done here. There are other instances of proving a negative, so it's not unheard of.
Right. This is a particularly difficult negative, particularly since you can be, you don't have to be a member of a tribe, have the connection for a tribe necessary to be an Indian under the statute, for example.
Well, I think it's difficult possibly in some circumstances, although I maintain that there are just a couple things that the government could do, or even if the investigation didn't necessarily uncover it, there are questions you could ask the witnesses that would provide some tangible basis for the jury's conclusion. And here we just don't have that. And I think that there are cases, there are cases where people plead guilty, and there's cases where a jury convicts and it doesn't go up on appeal on this question because the government has done its due diligence to meet the element. So I think Hebert and this case are somewhat unusual, and that Hebert is good because it does outline what really is not enough, and so it will inform investigations moving forward. But, the framework that I would say that goes to, because I think the ancestry piece is not that difficult. That's a question whether someone has Indian ancestry. It's a little more straightforward. I would say that recognition is a little mushier, but we have a list of things now from Hebert that go to that question. And I think if investigators can ask some of those questions or probe that inquiry, then it doesn't require some great volume of evidence to prove the negative. If I'll take any further questions, but I also would like to reserve some time for rebuttal.
Fine, go ahead. We'll reserve the time, remainder of your time. Ms. Dillon.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, Caitlin Dillon on behalf of the United States. Given counsel's argument, I will jump right in to tell the court that the United States presented sufficient evidence at trial to establish that Mr. Ruiz was a non-Indian for purposes of federal law. This testimony is readily distinguishable from the testimony that was given in Herbert for one primary reason. In Herbert, the testimony appeared to be scattered, and none of those witnesses provided a determination or a conclusion based on either their personal knowledge or their training and experience in some investigation. And that's what we have here in Ruiz. Primarily, we have criminal investigator Rome Wager from the Hickory Apache Police Department, who was familiar with the defendant in that he had seen him in the community both as a community member and an enrolled member of the tribe, but also as a highway patrol safety officer. He testified to his training and experience in terms of what he looks for in cases involving child sexual abuse cases and how those cases have a federal nexus and how he has to determine the non-Indian or Indian status of the victim and the defendant. And he testified that while he did not look at a tribal role, he looked at law enforcement databases that indicated that the defendant was born in Mexico, that he was likely a citizen of another country. And he confirmed and spoke with investigators from the Department of Homeland Security. And based on all of those things, criminal investigator Rome Wager made a determination that the defendant was non-Indian.
Well, we don't know. He says he had this discussion with Homeland Security. There's no evidence about what was discussed, what he learned. The most concrete fact we have is that Mr. Ruiz was born in Mexico. And that's not enough, is it?
Your Honor is correct in that the contents of that specific conversation were not brought into the trial record.
Well, and the other testimony was, this is my normal practice, but there was never any testimony, and I did that in this case. I mean, I think this case, there doesn't seem to be a lot offered to try and prove this particular element.
Arguably, the evidence in Hebert was stronger than we have here.
The United States respectfully disagrees with that, given that this testimony is analogous to the testimony that was given in Diaz and in Walker. When you look at Diaz, the court found that evidence was sufficient to establish that the victim in that case was non-Indian for a few reasons. That was related to the ancestry. That was an ancestry-specific inquiry. And the person in that case, the victim's family member, said that when they were in college, they researched genealogy and they came to a conclusion that the victim was non-Indian. We have that same scenario here, albeit with law enforcement. Law enforcement, based on their training and experience, did some research. There's a mention of a government.
What research? What research did they do? They said he was born in Mexico, and they had a conversation with someone in Homeland Security that we don't know what was discussed or what they learned. They didn't check tribal roles. I guess I think that Judge Timkovich is correct, that there was a lot stronger evidence in Hebert than we have here.
By the way, it just takes, you said his name is Herbert, and there was some confusion about that in the record. We used Hebert because that was on the district court docket, but was his name actually Herbert?
I am not sure, Your Honor. I might have butchered that horribly, but I am talking about the case that came out November 18th. That I will acknowledge is not great for the United States.
Okay.
And so when we look at Diaz and then we turn to Walker, which was a different standard of review, the testimony that was given in Ruiz is substantially similar to the testimony in Walker that was accepted by this court. In Walker, Sergeant Lindsay testified that he had contacts with the individual. He was familiar with the individual.
But let me stop you. There was no sufficiency of the evidence argument in Walker, correct?
That is correct, Your Honor. It is a different standard. However, the testimony is substantially analogous in that it is a law enforcement officer doing an inquiry as they are trained to do, conducting that inquiry and then coming to a conclusion that a defendant is non-Indian based on their training and experience. The officer in that case was cross-deputized with a tribal nation, and he was familiar with McGirt, and he testified that as part of his investigations, he had to undertake.
But the court in Walker never ruled on anything to do with whether that was sufficient on Indian status. All the court ruled on was an evidentiary issue about whether that testimony could come in.
That is correct, Your Honor. And the court ruled that the officer's testimony was sufficient to show that the officer had personal knowledge of the defendant. And that is the same here. Indeed, the testimony established through both primarily criminal investigator Wager's testimony is substantially the same in that he had some personal knowledge of the defendant based on his duties as a highway patrol officer and as a criminal investigator, and he came to a conclusion that the defendant was non-Indian. Similarly, we have Special Agent Pierre Himmel from the FBI who testified to his extensive training in Indian country jurisdiction, who reviewed documents that were signed by the defendant under penalty of perjury. They were government documents.
But all those documents said was, I was born in Mexico. They didn't say I'm not an Indian.
The text of those documents didn't make it into the record. Special Agent Pierre Himmel testified that his conclusion that the defendant was non-Indian was partly based on the fact that he was born in Mexico, but was also based on his investigation and review of government documents, based on his training and experience, which informed his conclusion that the defendant was non-Indian.
Yeah, I think in Hebert, the defendant also identified as Hispanic, and maybe he was born in Mexico also. And, you know, we didn't credit that much in that case.
The testimony,
but you know, if it's a totality of the circumstances, it seems like it's a good start. But you know, Hebert erects a lot of roadblocks to getting to the final destination.
it does erect a lot of roadblocks. And in terms of speaking specifically to the testimony in Hebert, there was testimony that the defendant had stated that he was half Mexican. We have substantially more here in Ruiz, where we have a statement as evidence that the defendant was born in Mexico, which makes it likely that he could have been a citizen of outside of the United States, which makes it much less likely that he is a member of an American Indian tribe that is federally recognized by the United States. And so that is the distinguishing piece here. And this court has recognized that racial identifiers are, do not go to that and are substantially different from the jurisdictional issue of non-Indian in this case. Absent any other questions on the non-Indian status, I'd like to briefly address the time frame of the indictment, as well as the fact that the Allen instruction was not coercive in this case. In terms of looking at the indictment, the district court correctly denied the defendant's motion to dismiss. The district court found that the indictment itself was constitutionally sufficient as to the elements of the offense. This indictment was reasonably particular as to time. It afforded the defendant fair notice of the charges against him, and importantly, allowed him to defend and protect against double jeopardy. The 4-year time frame alleged in the indictment is reasonable because it was drawn from Jane Doe's best recollections of when the abuse occurred, when the pattern of abuse occurred, from both start 4 to 5 years old to finish 7 to 8 years old, and it captured the multiple instances in between. As outlined in this court's recent decision in Garcia-Limon, importantly, this indictment balanced a few things. It allowed the government to accommodate a child victim because this court noted and cited to Valentine v. Conta that these constitutionally broad timeframes or these broad timeframes have been held to be constitutionally sufficient in cases involving child abuse. And so it allowed the United States to accommodate a child victim who was very young at the time that the abuse was alleged. And it allowed the defendant to be protected from double jeopardy because the United States, in using this 4-year timeframe, accurately captured the abuse as it was alleged and cannot charge the defendant again for instances of abuse involving this defendant during this time frame.
Has the defendant identified any prejudice from the 4-year time frame and what looks like a change from a series of molestations to a single event?
I believe the defendant has not identified a prejudicial effect from what was effectively the constructive narrowing of the indictment the morning of trial, sort of a game day decision at that point by the court. The defendant was always on notice of that act as being a discrete act that Jane Doe could identify. The other 10 to 12 instances of abuse were what I would refer to as carbon copy or almost cookie cutter that the United States could not necessarily charge under prevailing case law.
And when they settled on a single charge, it was a charge that occurred during the summer. Is that correct?
That is correct, Your Honor. It was the charge that the child had identified. She remembered, pursuant to her testimony, that it was warm outside. Importantly, about that time frame, in terms of asserting a defense, the defendant did claim that he was unable to assert an alibi defense, but due process has never required that an indictment lend itself to a specific defense. Case law from the Sixth Circuit cited in the United States brief also notes that alibi defenses are necessarily very fact specific, and they are difficult when the defendant lives in close proximity to the child, as was noted in the testimony that the defendant was present on that property spring, summer, and fall, but not in the winter. So in this case, the defendant was able to assert a fairly robust defense. He was able to call an expert who testified as to child suggestibility and intended to inherently undermine the child's veracity and reliability at trial. Finally, the defendant was able to defend against double jeopardy. The United States has conceded throughout this case in multiple arenas that we cannot charge the defendant again for instances involving this child during that time frame. Turning to the Allen charge, since I'm running a little low on time, the modified Allen charge was not coercive in this case. The district court's instruction that was given comported perfectly with this court's pattern instruction, albeit with one removal. They removed the second paragraph that discussed cost and retrial. The language of the instruction was perfect in this case. It reminded the jury that the government bears the burden of proof and cautioned that no juror should surrender his or her consciously held convictions. And even though it is suggested and recommended by this court that the instruction come with the initial set of instructions, that is not a factor in determining coerciveness. That doesn't render this instruction automatically coercive, but this instruction was given in a separate instruction. When the court gave this instruction, it only gave the instruction. It did not poll the jury, and the case law that supports that is not inherently coercive. In terms of the timing of the instruction was given at approximately 2:30 in the afternoon on the first full day of the jury's deliberations. So they had deliberated at about 5 hours at that point. And then in terms of the timing of the verdict after the instruction, it was about 2.5 hours after the instruction was given, which this court has held previously in other cases. Arnie collects those cases. The United States cite those in the answer brief on page 28. And the 2.5 hours is significantly larger than the hour that this court has previously upheld. So subject to any more questions from this court, I would ask that this court affirm the defendant's convictions, and thank you for your time this morning.
Any questions from the panel? Thank you. Ms. Edelman, you have 139 left.
I believe that the government has somewhat overstated the evidence about Mr. Officer Wager's personal knowledge of Mr. Ruiz, or the testimony on that point. Everyone assumed, I think, that there was more testimony than there was, including the district court. And so, and the government in its closing argument at trial also talked about Rome Wager having testified to personal knowledge and knowing that Mr. Ruiz wasn't a member of the tribe. That never happened. And he didn't, I think the only personal knowledge he offered was about maybe recognizing the truck. So that really shows, had that testimony existed, we might be, again, in a different place. I would just like to briefly address the indictment. The government. Well,
I'm not sure. Let me stop you.
Oh.
You can't reserve an issue for appeal and then save your time so that you can rebut. If you're going to make an argument, you need to do it. So I'll give you your 35 seconds to do that, but not 1 second more. Go ahead.
Oh, well, that's okay. I'll just say that the birthplace in Mexico is not probative of the pertinent question. We know that from Hebert. We also know that from Romero. And so we all know that you can be born, your birthplace has nothing to do with your ancestry in this country, and it doesn't tie into the pertinent factors. It could maybe also with more, with checking some roles or talking to people about tribal connections, but that isn't in the record here. And for those reasons, I ask that this court remand the case and vacate Mr. Ruiz's conviction. Thank you.
Thank you, counsel. Case is submitted. Counsel are excused. We'll be in recess until 10:45 a.m.
Here they come. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Thank you. We'll begin with our next case for oral argument this morning, 24-2136, United States versus Hayman. Ms. Johnson.
May it please the court, J.K. Theodosia Johnson on behalf of Ms. Hayman. The parsimony principle governs sentencing, that it has to be sufficient but not greater than necessary. And the maximum sentence is reserved for the worst offenders, the ones who are most culpable. And Ms. Hayman, who has an IQ of 63, believed a parody website was real and cannot live alone, has a plenary garden, is not the worst of the worst. The district court failed utterly to consider how the intellectual disability affected all the sentencing factors, and it does affect them all. It affects retribution because intellectual disability is inherently mitigating and it reduces culpability. It affects deterrence because, again, the intellectual disability affects cognition and your ability to reason things out. And it affects deterrence in that general population is not going to have the same reaction to a punishment for an intellectually disabled individual as it does for themselves. They do see themselves as categorically different.
Now, we've repeatedly said we don't reweigh the factors. So you'd have to show that the court, wouldn't you have to show that the district court simply didn't consider this?
Yes, and I think that when you sentence it to the statutory maximum without ever discussing it, we did show that the judge never considered Ms. Hayman's intellectual disability. We're not asking this court to say to reweigh it. We're asking them to look at it in light of the fact that she never mentioned it and that it is inherently mitigating. The Supreme Court has told us that. And with that information, she at the very least should have said, I find that that even though she has intellectual disability, her culpability is less. Or her culpability is less for this crime. But also, she relied almost solely on dangerousness, which derived from stereotypes of those with intellectual disability instead of any sort of actual testing to show dangerousness. And that any of these, she says these prior acts, didn't result in convictions, but they didn't even result in arrests. I mean, the one time that she managed to do anything when she went to Mexico, as soon as she was confronted with any sort of deterrence, that's not quite the right word, but she immediately turned around and left, but she needed help to leave because she had already left her ID somewhere. This is not someone who is dangerous. And, the government kept pointing to, she kept contacting this parody website, but you're using the very intellectual disability that Atkins has told us is mitigating as evidence of dangerousness.
I'm looking at the sentencing transcript, and really there was a fulsome discussion of the defendant's history, and the defendant participated in much of the colloquy. So, we're not looking at this in a void. It really looks like it was a solid back and forth between the defendant's lawyer, and the court. And a lot of these cases, we don't really see that. They were much more perfunctory. Where do you think Judge Strickland went off the rails here? Because the developmental disability was front and center as part of the presentation. So it's not like she didn't, she just ignored it. It was part of the context of the entire sentencing hearing.
Well, I think one of the things in that Atkins talks about is that those with intellectual disability have difficulty with expressive and respective language, and that very often that sort of translates into lack of remorse, which I think Strickland took from this, and a just general reliance on, instead of what we actually know about intellectual disability, on the stereotypes of what we think it should look like or has looked like in the past. And like, again, the Supreme Court has said that you need to look at what it actually does and what it actually is, and the scientific basis of intellectual disability and how it affects their actions. I mean, remember that she had a plenary guardian. When she tried to actually go and meet with the alleged hitman, she couldn't escape her caretaker, and her caretaker prevented her from going there and told the alleged hitman that they had already called the police. Like, this is not your worst of the worst of the person that use of interstate commerce for murder for hire is designed to get at. I mean, they passed it to reach mafia hitman. She's as far from a mafia hitman as it's possible to get. I mean, she's just, if the statutory maximum is reserved for the most culpable, she needed to explain why this person who believed a parody website that is over the top and is designed to be so was actually real, and who has a plenary guardian, has never lived on their own, will never live on their own, deserves the same sort of punishment as one who is fully cognitively aware and went out and contracted for someone to kill an individual. I mean, it boils down to, like, yes, it was in the, I'm sorry, Judge McHugh, were you asking a question?
Oh, your mic's off, Judge McHugh. Judge McHugh, you look like you're speaking, but your mic is off. Huh. Can't hear you. There we go.
Okay, it said the host had to unmute me. I think you muted me, Harris.
Thank you, host.
We did that on purpose.
Okay, my question is, where the court did go through the 3553A factors, how much discretion do we have? I mean, even if we might have sentenced differently, how much discretion do we have here to reweigh those factors and say that the intellectual disability here should have been weighed more heavily?
Well, I think so one of the problems, obviously, right, is that it gets murky between procedural and substantive reasonableness. And when you're left in the zone of speculation about what weight or consideration a factor was given, which is exactly where we are right now, you have to reverse for further discussion for resentencing. And in cases like Crosby and Cookson, where they're kind of glossed over, they're like, well, I find that it's necessary for deterrence, but don't discuss how it deters either that specific individual or more general individuals. This court has said that's not sufficient, and I think that's where we are here. I mean, everything about the sentencing had to be looked through the lens of intellectual disability, and it needed to be at least acknowledged. And she never said the words intellectual disability in talking about it. And when the first factor, right, it goes to retribution, and we know that they're less culpable. It's inherently mitigating. The Supreme Court has told us that over and over. And in that background, you have to at least say, she, even with all this, inherently mitigating stuff, I think she's still culpable as the worst of the worst because X, Y, and Z. But X, Y, and Z don't really exist here. So it's not that we're asking you to reweigh it. You have to look at the entire thing through the lens of intellectual disability, and there's no evidence that she did that.
So is this a procedural error? Did you raise the defense counsel in district court say you have not given an adequate explanation?
No, and he did say when she asked, no, but he did continue to immediately argue about the sentence. I also think that given Ms. Hayman's status, I think it's unfair to impart that knowing and intentional waiver to her. But also it's right on that line.
We're not talking about knowing
right?
intentional waiver. We're talking about forfeiture, which is not necessarily intentional. The question is whether we review for plain error in this regard.
You would have to revert for plain error, but it's really on that line because we know that procedural reasonableness bleeds into substantive reasonableness. It gets a little murky because it's the adequacy of the explanation, and can we engage in good review, in an appellate review? And I think that's lacking here. And the First Circuit found itself in the exact same position and said, this isn't really a procedural problem. It's so invasive and it's the mitigating factor that it is substantive. It's not procedural.
What case are you referring to there?
It's Colon Cordero. I don't have the citation right off the top of my head, but I did cite it in the reply brief, and I can't. Okay. And also, I mean, if you look, so Dr. Abil, who was the BOP doctor, never opined on dangerousness or even the offense. But Dr. Kaufman, who had extensive experience with Ms. Hayman, pointed out how ridiculous this is, right? Because on the face of it, it sounds serious, right? She tried to contact a hitman multiple times. You know, she met with them, all that. But when you look at what it actually is, it's as Dr. Kaufman said, ridiculous. I'm going to reserve the remainder of my time because I'm essentially just repeating myself.
I think you're right in that. I think we understand what your argument is.
So,
thank you, counsel. Ms. Messick?
Good morning, Your Honors, and may it please the court. Paige Messick for the United States. Hayman's 10-year sentence for attempting to have a woman violently murdered was reasonable in every way. And I'll jump back in where you all just left off with substantive reasonableness. The district court imposed a sentence of reasonable length under the 3553A factors. Having a mild intellectual disability does not compel a district court to conclude that a defendant deserves a downward variance from the guideline range, not when the crime is so serious and the defendant has a history of putting other dangerous plans into action.
Let me ask you a specific question. When looking at the transcript from the sentencing hearing, does the court specifically discuss the impact of the intellectual disability on the evaluation of the 3553A factors?
No, Judge McHugh, the district court did not specifically address intellectual disability on the record.
Do you think that it needed to under some of the Supreme Court authority about how important that is in assessing culpability?
No, I don't think that the district court was required to address that on the record, either under those Supreme Court cases or under this court's precedent about what a district court has to specifically say in imposing a guideline sentence. Because it's obvious from the sentencing record what Judge Strickland was concerned with. Judge Strickland was very well aware of Hayman's intellectual capacity. Judge Strickland had presided over a full-day hearing on competency earlier in the case, started the hearing by saying, "I've considered your arguments," ended the hearing by saying, "I've considered your argument for no more time," and the intellectual disability was the core piece of that argument. As Judge Timkovich said, this issue was front and center. And so when the district court says, "I'm really concerned that you're a danger to the community, I'm concerned with some of the stuff in your history, and this crime is an extremely serious one," and then gives a sentence at the statutory maximum, you can tell that Judge Strickland has determined that Hayman's intellectual disability does not outweigh or does not neutralize those other factors, right? So it may be inherently mitigating. At least part of it is. At least part of the intellectual disability has some inherent mitigating effect on culpability, for instance. But it can also have an effect that offsets that in the way that the intellectual disability may affect Hayman's ability to exercise good judgment. And so the district court certainly is within its discretion to conclude that this disability does not outweigh these other important factors. And I don't think that it has to say so on the record either.
Well, how would you distinguish Colon Cordero then?
Colon is a very different case. First, because there was a lot more explanation in this case, right, than was on the record in Colon. And also Colon is an upward variance. And that makes a huge difference because there are two different frameworks for what a district court has to say in explaining its sentence that depend on whether the sentence is a guideline sentence, as we have here, or is an upward variance, as was the case in Colon. If the district court imposes an upward variance, the district court has to address on the record every non-frivolous argument that the defendant makes for mitigation, every material non-frivolous argument. And so if this were an upward variance, we might have an insufficient explanation, but it's not. It's a guideline sentence. And it's a guideline sentence that where the guideline was already lowered substantially to the statutory maximum. But the entire framework that the First Circuit applied in Colon is not the right framework to apply here. This court should apply Munoz-Carranza and all of the cases that talk about the amount of explanation that's necessary for a guideline sentence. I would also like to touch on the forfeiture and waiver point. Here, we don't just have a forfeiture of this issue, we have an affirmative waiver because defense counsel, in response to a direct question from the district court about the adequacy of its explanation, responded, "Your Honor, I do not object to the adequacy of your explanations." And when you say that, you shouldn't be able to object on appeal to the adequacy of the explanations. This is not the sort of question that we sometimes see, a general question at the end of a sentencing hearing where a district court says, "Any further objections? Seeing none, we're adjourned," right? This wasn't that. This was direct and it was targeted. And if this
in this case, immediately after saying that, defense counsel pivots to the main argument. And don't we have some authority, Zubia, Torres, that suggests when counsel does that, it's not necessarily that they're really intending to waive, they're just trying to pivot.
I'm not familiar with that case, Your Honor. I would say here that what defense counsel did was say, "I don't have an objection to the adequacy of your explanations." That's what you just asked, you Judge Strickland, right? Let me move on and talk about the length of the sentence you just imposed, right? So I think this is an intentional, it is a pivot. It's a pivot to the place where the defendant still has an objection. If Judge Strickland cannot avoid a waiver by asking a specific question like this, then I would ask the court, please tell us what words would accomplish that kind of waiver, because it seems to me she is doing absolutely everything she can to elicit an objection at the time that she can still address it. And it doesn't seem efficient or fair to allow someone to answer this kind of very specific question about a narrow issue with "No, I have no objection to that," and then turn around and raise the exact objection that they've just disclaimed when they're on appeal. So if this isn't enough for a waiver, I would just ask that the court try to provide us some more guidance, because we want to do what we can to get sufficient explanations out. Judge Strickland wants to do that. You can tell through her careful questioning. And so I think I've made my point there. We also had a question about the calculation of the guideline range in this case. I'm happy to rest on the briefs as far as that, unless the court has any questions. Moving back to the adequacy of the explanation, I think under Munoz-Carranza, we clearly have an adequate explanation. In fact, we have more than what was required in that case. The district court here clearly entertained defendant's argument for a downward variance. She opened the sentencing hearing by saying, "I've read your briefing, I've looked at the PSR." She then engages actively in the questioning during the sentencing hearing. She's expressly considered the 3553A factors. She says, she goes through them all in the record, not just says I've considered these factors, but actually goes through and pauses to elaborate on the factors that are the most important here to her decision. This is more than enough under Nunez-Carranza.
I think what the argument is, if I'm understanding it, is that yes, she went through the factors, but she was supposed to look at those factors through the lens of the substantial intellectual disability of this particular defendant. And there's nothing in the transcript that reflects that that was done. How would you respond to that argument?
I think when Judge Strickland says the things that really concern me are the seriousness of the offense and the danger that you present to the public and the other people that you have tried to harm in the past, Judge Strickland is necessarily saying, I don't think your intellectual disability keeps you from committing serious offenses and being a danger to the public.
Well, I mean, you're inferring that. And I guess the question is, did we need something on the record to tell us that she considered that?
I guess that is an inference, but I think it's a very strong one from the record. And no, she doesn't need to do anything specifically to put that on the record. The court's precedent is clear that in imposing a guideline sentence, the district court does not need to affirmatively reject on the record each argument that the defendant makes for a downward variance. So there's no procedural requirement that Judge Strickland did that here. And I recognize that the explanation blends with the substantive reasonableness of the sentence because it assists this court's review. But I'm not aware of any case that has found that an explanation that is procedurally sufficient is nonetheless insufficient to enable meaningful appellate review. Here, there's no question why Judge Strickland is imposing this sentence. She's very familiar with Hayman. She's familiar with Hayman's intellectual capacities. She's read the briefing. She's considered the arguments. She's simply not persuaded. And I think that that's quite clear. And she even highlights the reasons that she thinks that 120 months is the absolute minimum that will meet these factors. I don't think anybody has been left in the dark here. If the court does not have any further questions, I'm happy to return the remainder of my time.
Any further questions from the panel? Thank you, Ms. Messick. We get Ms. Johnson back on. I think she had a couple minutes left.
All right.
Yes, good.
So going back to the dangerousness, Judge Strickland cherry-picked facts of this one trip to Mexico where, again, when she was actually met with real-world resistance, she immediately did nothing. All the others were merely plans or exclamations of, I really want to kill you, which directed at your mother-in-law may not be the most unique statement ever made. And then again, like she says, I'm given her behavior in this case and given her behavior in the past, but her behavior in this case is ludicrous. I mean, she couldn't escape her caregiver. She could never have gotten to Bayard, which is where the supposed victim lived, by herself. She never had a driver's license. She contacted a parody website over and over. You can't use the same evidence of intellectual disability, which is what that repeated contact shows, as evidence of dangerousness. As, Atkins warns explicitly against that. On
the waiver issue, the defendant's lawyer, Ms. Poissant, specifically said, quote, "Your Honor, I do not object to the adequacy of your explanations," close quote. Why isn't that pretty much a clear and unmistakable waiver of the challenge that you're making on appeal?
Even if it is a waiver, we can still consider it as a substantive error in the sentencing. And if we find ourselves in the zone of speculation, where I think we clearly are, it's substantively unreasonable. I do think I should have read the record a little more carefully there. But the immediate pivot to, but 120 months is unreasonable. And I mean, I can hardly be pointing fingers at being inarticulate, but he doesn't say, it's not the sentence. I can't remember exact words, but it was fumbled, which like I'm fumbling now. And I want to point out too, like with the cross-reference, any sentence is going to be above the guideline range. I can't remember exactly, but with that cross-reference, which they've applied in all cases, it's always going to be above the 120 statutory max. And, I just going to return to
cross-reference, you were definitely on plain error, right?
We were definitely on plain error in the cross-reference.
And we don't have, there's no law, right?
The 10th Circuit has
nothing that would make it plain.
No. But I'll just return to the statutory max is supposed to be for the worst offenders who are most culpable, and Ms. Hayman is not that. And I would ask you to reverse and remand because the sentence is substantively unreasonable. It is manifestly unreasonable. Thank you.
Thank you.
Thank you, counsel. Counselor excused, case is submitted. And if you'll set up our next case, Mr. Gruen. Looks like everyone's here. So we'll start on 24-8070, United States versus Griffin. Mr. Rashabot. Pronounce your name for me, I'm sorry.
Rashabot.
Rashabot, okay.
May it please the court, Jake Rashabot for the appellant, Mr. Griffin. Section 2252A imposes a 10-year mandatory minimum if the defendant has a prior conviction for a state offense relating to possession of child pornography. Under Bennett, the offense need not be a perfect match for the federal definition. However, this court still looks to the least culpable conduct under the statute to determine whether it's an offense categorically relating to the federal definition of child pornography. Under federal law, images must depict sexually explicit conduct, which at a minimum requires lascivious exhibition of the anus, genitals, or pubic area. The California statute, on the other hand, applies to images that are decidedly not pornographic, images that appear to be wholly innocent. That's because the statute applies to any physical touching, including dancing or hugging, so long as the defendant had a lewd state of mind. Accordingly, it is not an offense categorically relating to child pornography, and this court should reverse the application of the mandatory minimum sentence.
What do we do with United States versus Bennett?
Well, this court is bound by United States versus Bennett, and it is, which said that this court does apply the categorical approach, but I'm not arguing that that even the slightest bit of overbreadth in the California statute, as compared to the federal definition, is enough to make this not related to child pornography. I'm saying the California statute.
Bennett also said that the enhancement doesn't limit pornography by linking it to the federal definition, right?
My understanding of Bennett is that...
That's a quote. I just read it from Bennett.
I understand, but I still believe you compare to, even though there can be some overbreadth with the federal definition of child pornography, the statute, when it says child pornography, the federal definition necessarily applies there, because the federal definition of child pornography appears in the same chapter. So while there doesn't have to be it doesn't have to directly mirror or follow, the state statute doesn't have to be a categorical match for the federal definition. It still has to categorically relate to the federal definition of child pornography. So relating to expands what is what the state statute can prohibit beyond the federal definition of child pornography, but the federal definition is still sort of providing that sort of original comparison, the comparison that you do. And here, the California statute, even if we're not comparing it to the federal definition of child pornography, even if there is no federal definition of child pornography, the California statute goes so far beyond what anyone would consider to be pornography. That's because it incorporates, so it applies to depictions of any act under another California statute, 288. And the California Supreme Court has held that Section 288 is incredibly broad and amorphous. It applies to any form of physical contact with any part of the body, so long as the person doing the touching had the subjective lewd intent. So
can you compare for me the Colorado statute in Bennett with the California statute here? Does the Colorado statute require nudity or images of the genitals or breasts? Is that?
Yeah.
In other words, does it require more explicit images than the California statute? If so, just tell me what the differences are.
Much more so. So the Colorado statute at issue in Bennett was only overbroad as compared to the federal definition because it included the lascivious display of breasts as opposed to just the anus or genitalia. And it also applied to where a child was observing explicit sexual conduct. So this court still said that even that overbreadth is not enough. It still is an offense relating to child pornography because the nature of the offense is still material depicting a child participating in explicit sexual conduct. So that really is the core feature of child pornography under any definition. It has to involve a child, and it has to be, the images have to be pornographic. Under the California statute Mr. Griffin was convicted under, there is no requirement of any pornographic, any sexually explicit. It doesn't even have to have the suggestion of sexuality. So, for example, under federal law, we look to the Dost factors to determine whether something is objectively pornographic, that whether it actually is child pornography. And here, the California statute applies where none of those factors do. So where there's no depiction of genitalia, let alone that it's the specific focus, where the setting is not sexually suggestive, where the minor is not depicted in any unnatural pose or inappropriate attire, they're fully clothed, there's not even a suggestion of coyness or willingness to engage in sexual activity, and the visual depiction isn't designed to elicit a sexual response. So even wholly innocent appearing photographs can be the basis of a conviction under the California statute, and therefore it doesn't categorically relate to child pornography.
Does the California statute have a title? It's section such and such, and then is there some language after the section number?
I'm sure it does. It doesn't say child pornography. Off the top of my head, I'm not sure what it is.
It looks like it says certain activities relating to material constituting or containing child pornography.
I apologize.
That's from 2252A.
But even then, I mean, as I argued,
but you said what it covers, no one would consider child pornography. I probably wouldn't, but California is a big section of this country, and that's what their legislature called it.
Well, I mean, as this court has held numerous times, the title of a statute might be can be relevant, but it's certainly not dispositive, and it's never dispositive.
Yes, but your statement was no one would consider this child pornography.
I think no layperson would, and
not just legislators. You have impugned the California legislature, but that's fair game.
Well, so for example, though, I mean, as I pointed out in the reply brief, I mean, Texas considers theft of a vending machine to be burglary. And notwithstanding that, I would still just say as a general matter, I don't think anybody, and I guess maybe I'm only speaking of lay people here, would consider robbing or would consider taking a candy bar that's dangling to be burglary. It just wouldn't occur to anybody. And so the California statute, I mean, the sort of defining feature of pornography, to borrow from Justice Stewart, you know it when you see it. And that's what pornography might be hard to define, but it's not hard when you're actually looking at it. And the California statute applies to images that a person looking at it could have no idea that it is quote unquote pornography.
Well, I guess you somehow have to know what's in the head of the adult, right? In the picture.
Exactly. Which, you know, that in order to be convicted, you do have to know. But the point is that it is not pornography. There's nothing pornographic about the image. It's unlawful because it depicts a crime, but it is not under any reasonable understanding of what child pornography is pornographic.
Judge Hartz is enjoying too much any criticism of the California legislature.
And it really is just the product of the fact that how the statute was written, that it includes the quote unquote child pornography statute includes depictions of lewd and lascivious acts. It's just that then the California Supreme Court went on to define that separate offense in this incredibly broad way that applies to any touching, so long as the subjective intent of the person had a lewd intent. So originally courts had interpreted it, or several had, as requiring them to be objectively lewd. And if the requirement, if the statute did require the touching to be objectively lewd, then presumably that would sort of, then a picture of that objectively lewd act could be considered child pornography. But where the lewdness exists only in one person's head, the image of that is not pornographic.
You still have some time. I don't see
a
question.
If there are no further questions, I would reserve the remaining of time I have for rebuttal.
No further questions from the panel? Guess not. Okay. Thank you.
Thank you.
Mr. Griswold, your turn.
Good morning. I think it's still morning, yes. And may it please the court, Seth Griswold, representing the United States on this matter. And I'm here to tell the court why the district court was correct in this matter when it ruled that the California child pornography statute undeniably relates to the federal definition, and this court should have little difficulty deciding that it is a predicate felony under 2252 AB2, and the defendant properly faced the 10-year mandatory minimum. The defendant has argued that the district court erred and that 311.11 is overbroad when you get to the least egregious conduct, the lewd and lascivious definition. But their argument, as just stated here today, hinges on a mischaracterization of what the California child pornography statute requires. As stated here, they repeatedly argue that there's only two requirements for an image to satisfy the child pornography statute, that being that it, one, depicts any physical contact with the child, and two, depicts subjective lewd intent. They argue that it can include decidedly not pornographic images, and that it can include wholly innocent images. But that is not the case. That is what is required for a violation of Section 288, a lewd or lascivious act. That definition is then incorporated into the child pornography statute under 311.11, but to be convicted under 311.11, it still requires that the defendant knew what he possessed depicted a minor engaged in sexual conduct, and that's the very important distinction here. As stated in Chavez-Solis, cited in my brief from the Ninth Circuit, when they were doing the categorical approach for this, and albeit that was for a little different statute comparison, but they, quote, state both the federal and state statutes require knowing possession, including knowledge that the pornography depicts a minor engaged in sexual conduct. And under 311.11, it, quote, says, knowing that the minor depicts a person under 18 years of age personally engaging in or simulating sexual conduct. Reading that, and if we have a third party that possesses the image itself must depict overtly sexual conduct. A third party possessing it must be able to know that it depicts that, and the state would have to prove beyond a reasonable doubt that the person knew that they possessed an image of a minor engaged in sexual conduct. And this is what then relates it to the DOS factors in the federal definition. The one that
if I could stop you there, the 311.4 in the, of course, it says it criminalizes any lewd or lascivious sexual act as defined in Section 288. So doesn't it bring in anything that could be considered a crime under Section 288?
It does, Your Honor. But then that is the definition of the sexual conduct. But then the image still must, the person possessing it to be found guilty, there's a further element that they must know that the pornography depicts a minor engaged in sexual conduct.
That's not in the statute, is it?
Yes, it is, Your Honor. If you look at 311.11 subsection A, I quote, knowing that the matter depicts a person under 18 years of age personally engaging in or simulating sexual conduct. And that is the key here that makes it so that we're not just talking about California and they're just letting anything be child pornography because they want to criminalize everything. No, it still is child pornography. And that's what I wanted to get to, the analogies that are discussed by the defendant, where he talks about just rubbing somebody's back could be lewd and lascivious acts so long as they had.
Where'd you read that the intent? Was that in 311.4A?
No, Your Honor, it's in 311.11 subsection A.
Okay.
What about
and so when you talk
People versus Martinez from the California Supreme Court, where it talks about it could have the outward appearance of innocence?
Yes, Your Honor. And so that case, though, is only discussing a violation of California Statute 288, which is a lewd or lascivious conduct. And that's where this is getting a little nuanced, because we are talking about using that definition within the discussion of a child pornography possession of an image of that act. But for defendant to be convicted of possession of child pornography under the California statute, they must then know that it depicts sexual conduct. And so that, I think the perfect analogy is talking about these somebody rubbing a back, and they could be convicted of 288 if they had the subjective lewd intent, but they could not be convicted. A third party possessing an image of somebody rubbing somebody's minor's back could not be convicted of subsection 311.11 because they couldn't know that that depicts a minor engaged in sexual conduct. The only way I could think of that is when we're more talking about when we look at subjective intent for purposes of a 2251 violation, production of child pornography, where maybe if that person was somehow involved in the making of the image and they could know what the intent of the person was doing and then they had the intent, that's the only way this could even possibly be prosecuted under the California state statute. And I think it's important to take a step back. You know, everybody agrees, I think, that we're talking about the categorical approach, not the modified categorical approach. So we can't consider it was actual child pornography he possessed. We have to look at the categorical approach with this broadening relating to language. But when we do the categorical approach, the court still looks at the most minimal, least egregious conduct that has a realistic probability of being prosecuted under the statute. So we can do these hypotheticals, but it still requires a realistic probability that it would be prosecuted. And even further, I think if we want to go down the endless hypothetical rabbit holes, the state still has to prove they knew it was sexual conduct. And thus, it is very analogous to the federal definition. And that's why I think when you read Reinhart in the Ninth Circuit, they say it is overbroad because it allows for the exhibition of any part of the body, not just anus, genitalias, or pubic area. And again, they differentiate themselves from the 10th Circuit because they take a different approach and do not read the relating to broaden the categorical approach because the definition's in the same chapter. However, they did that. So I think that's what's important here. And when you look to Bennett, which this court is bound by, relating to does have a broadening effect. As Judge Hugh pointed out, the enhancement statute does not limit child pornography by linking it to the federal definition. And Congress chose this expansive term to ensure that individuals with a prior conviction bearing some relation to sexual abuse or abusive conduct involving a minor or child pornography receive the enhanced minimum and mandatory sentences. And relating to is a broadening language. It then incorporates anything that stands in relation to, pertains to, has a connection to. And then Judge Timkovich, when you brought up the Colorado statute, the similarities, the United States, they're very similar, the differences between the California versus federal and the Colorado versus federal. The Colorado allowed any images that contain breasts but not genitals, and also just a child observing but not engaging in sexually explicit conduct. And Congress, Bennett found Congress characteristically employs this to reach all these more broader things. What's also important is Bennett isn't even the line. They never say that this is the lowest level or the most removed we can get. It's just an example of something that relates to the federal definition. And even if this court does find that the California statute is a little more broad than the Colorado's, it still undeniably relates to the federal definition. When you talk about lascivious, which it isn't even defined, and then the DOS factors, in my prosecution experience, one of the DOS factors I rely upon the most is 6, whether the visual depiction is intended or designed to elicit a sexual response in the viewer. And that's how we can get to some of the cases, such as what's cited in my brief, United States v. Helton, where you could have a minor in a bathing suit on a beach that can actually be child pornography depending on how it's framed. And the big difference there is, yes, it does require the genitalia to be in the image for the federal definition, but the California statute isn't that much different. It still requires that they know it relates to sexual conduct. And while, yes, the lewd or lascivious act for 288 is quite broad, and you have to go into subjective intent, and you have to look at the totality of the circumstances, the actual child pornography statute still requires that knowledge, and it has to be proven, and that's what brings it within the same realm of the federal statute. One of the other analogies that the defense brings up in their reply brief is talking about Pugin v. Garland, which was analyzing the broad language of relating to in context of an obstruction. And they argue it supports his position, but it actually supports our position more because, as said in Pugin, an offense relates to obstruction of justice only if it categorically involves an objective or intent to obstruct justice. And that's exactly what we have here. 31111 requires that intent, that knowledge that it's a minor engaged in sexual conduct. So all of these wholly innocent, decidedly not pornographic images that the defendant complains of could never be prosecuted in California, and certainly there's no realistic probability that it would be prosecuted. And for those reasons, in the end, the analysis is simple. It's whether it relates to, connects to, pertains to the federal definition. And 31111, while is broader, is only slightly so because it does allow any touching of any part of the body. But besides that, because of the knowledge requirement, the United States does not believe any broader, nearly as broad as the defendant is putting forth. And for those reasons, the United States asks that the court affirm the ruling of the district court in the sentence in this matter.
Let me focus you for a minute on section 311.4, which defines sexual conduct under the California statute. And as a separate category of sexual conduct, it has lewd or lascivious sexual acts as defined in section 288. The 288, I mean, the difficulty here with the statute is the definition in 288. It is very broad. You'd agree with that?
Yes, Your Honor.
So by defining it as sexual conduct standing alone, does that support the defendant's argument here?
It does not, Your Honor, because the individual who possesses the image and is charged under 311.11a would still have to know that it's sexual conduct. And that could be done in numerous amounts of ways. You can prove intent through circumstantial evidence, the totality of the circumstances, and either it would have to, on its face, be sexually explicit so that they could know that it's sexual conduct, or to get down to these analogies of just rubbing on the back and touching of any body innocently, quote unquote, but with that subjective lewd intent. The only way they could then be prosecuted under that is if they knew the subjective intent of the person. So say you had two people that are grooming a child and one knows that the other one is touching the child with that subjective lewd intent, then perhaps I could see a case where then a person could be prosecuted and convicted for possessing what some people might think on its face is a seemingly innocent photo. But
and
then
wouldn't that, in that instance that you've just identified, be categorically broader than the federal definition?
Only because of...
you could have an innocent depiction, somebody, rubbing a kid's back, and two, maybe they're co-conspirators, I don't know. They happen to know it's a grooming exercise and there are lewd and lascivious thoughts going on in the head of the adult in the picture. I mean, that's broader, isn't it?
Only because it allows touching of any other body part, not just the genitalia. That's the only reason it's more broad. I have prosecuted cases where somebody recorded a video of a minor rolling on the floor, and we were able to prosecute under 2251 because of his subjective intent. He ended up admitting it was because for his sexual gratification. So anybody, you or I viewing the image, would think it was wholly or innocent, but when you looked at the DOS factors, and that's again why I point to the court to that 6 factor, something you do have to have that focus on. The genitalia has to be included in the federal definition, but then you look to whether the visual depiction is intended or designed to elicit a sexual response in the viewer, and that's the subjective intent. That's the subjective lewd intent of the person who's producing or possessing the federal child pornography images, and that's why they are so related in this case.
Well,
if somebody,
I'm sorry. Go ahead. I'm deferring to you.
I was, just following up on that. If rubbing the shoulders could be fit within the federal definition, somebody pinching the shoulder, an adult pinching the shoulder of a child, could that be prosecuted under the California law 288? If the person pinching the child had a lewd and lascivious motive?
I think reading it on its face and analyzing the Martinez statute, that if the state was able to prove beyond a reasonable doubt the subjective lewd intent of the individual, they could be prosecuted under 288. but an image of that could not be prosecuted under 31111 unless if there is evidence that the person who possessed that image knew it depicted a minor engaged in sexual conduct.
Okay, got it.
And I apologize for going much over my time. If there's no further questions,
You were responding to questions. That's fine. But I think opposing counsel is entitled to a little 4 minutes, 20 seconds of rebuttal. So we're ready for you now.
Thank you, Your Honor. Quick clarification, section 311.11, which is a California statute. I don't see child porn anywhere in the title or the text. It says possession or control of matter depicting persons under 18 years of age engaging in or simulating sexual conduct, digitally altered or AI generated matter, punishment, previous conviction exemptions. So I'm not sure where the child porn language comes from, but I don't think it's the name of the statute. As to this idea, I've never claimed that somebody could innocently possess one of these and then be prosecuted under the California statute. That's not what I'm saying at all. What I'm saying is the actual content of the image would appear to any objective observer not to be pornographic or sexual in any way whatsoever. It would just appear to be depicting innocent conduct. Now, if there was a picture of, like, let's say somebody took a picture of themselves with a teenager with lewd intent, and they, take a selfie and they have their arm around them, if their subjective intent was lewd, then they have now committed, they violated section 288. And if they possess that picture, then they violated 311.11. What opposing counsel is talking about is difficulty of proving the violation, but that's not what we're talking about here. And he brings up the realistic possibility of prosecution, but again, that's not saying would it be difficult to prove. What that's saying is, in some cases, not here, you need to provide where we've come up with these sort of crazy hypotheticals of how somebody could be prosecuted under the statute. You only have to show examples of prosecution where the defendant is interpreting a generic term in a non-generic way. You don't have to provide specific examples of prosecution when the statute on its face and the Supreme Court's interpretation of the statutes plainly apply to that conduct. So here, as opposing counsel just conceded, based on the plain language of the statute and Martinez, you could be prosecuted for exactly that.
So as I understand you, since the statute is clear of what's prohibited, the fact that it's highly unlikely that anyone would be prosecuted for some of that conduct is not relevant in this context, because all you're doing is interpreting the clear meaning of the statutory language. Am I correct about that? Am I understanding?
I think highly unlikely in that it would be difficult to prove. I don't think is relevant. But again, I actually don't think I think he's overstating how difficult to prove it would be. You can imagine a scenario where somebody is caught as, perhaps with a hands-on offense, and then you look at their phone and they got a bunch of pictures of them with touching children. And even though those pictures at the time appeared to be totally normal, we now know, those are sort of like trophies of prior violations of 288. So I don't think it's particularly far-fetched. And, counsel cites Chavez-Solis. Chavez-Solis talks about exactly this issue, which is the realistic probability of prosecution. And it cites saying defendant doesn't need to cite a specific case here because the plain language of the statute and Martinez clearly show that you can be convicted for that. And in any event, they do cite some California cases where 288, a lewd touching under 288 was the basis of a child porn conviction.
Thank you, counsel.
All right, thank you.
Okay, you have 6 seconds, but
I would cede the 6 seconds. Ask this court to reverse.
You'll cede your 6 seconds. You're most kind. Thank Thank you, counsel. Case is submitted. Counsel excused. Court will be adjourned.